just a little bit over a year, October. So this will be the first one of this year. And like she said, we record these so that we can post them and have others be able to watch them at another date. So if you're familiar with this format, or if you're not familiar with this format, what we do is 2 hours for part one tonight. And then we do 2 hours for part two next Thursday. So this coming Thursday. So if there's something that you didn't catch in the first one, you can either watch it in the video when we post it, or you can use the chat function to ask your question and we'll catch it next time. Or I'll try to watch the chat if you have a question or if there's something that I gloss over that wasn't really clear. It's entirely possible I say something that mixes up my words or isn't as clear as it should be. So feel free to use the chat and ask questions. But I have a bunch of slides. I think there's 40 something. I'm not going to cover all of the slides. We post those too. Just kind of depends on how the time goes and the flow is. But basically, what we'll cover in part one is starting at a high level view of the development process, starting from beginning and then going to end. And then we use part two to delve into a little more detail on some more specific issues like covenant amendments, enforcement, collections, insurance, those kinds of things. So with that, I'm going to share my screen and we will um, we'll look at the slides that I have prepared. Let's see. Really distinguish between that. Just use HOA as a catch-all. I'll do the same thing with dues and assessments, but when it's important to make a distinction, I'll certainly try to do that. And there are some important distinctions between a homeowners association type setup or development and a condo association. Like I said, where it's important, I'll identify that. But let's start with the very beginning. So we have a piece of real estate or dirt, a developer, if they're developing in a municipality, say Tulsa or Broken Arrow, Oklahoma City, Norman, Mustang, Yukon, Edmond, any of those municipalities, they're going to have a body of ordinances that requires a community association to be created. So sometimes there's a question of why do we even have this thing? Let's just get rid of it. It's such an annoying thing to have to deal with is this association. Well, most of the time, the reason you have an association is because there's a municipality who has said you have to have this if you're going to have drainage areas or common areas. And so that may be the answer why. If there's a private road, there has to be a entity or a mechanism for maintaining that private road because the county or the municipality, wherever the property is, isn't going to maintain it because it's private. So that may be another reason why we have an association. One of the things that I think is a common misconception, and the idea is, okay, the association exists for the purpose of enforcing the covenants. And while it is possible, maybe even likely, that the association ends up being the primary entity within a neighborhood enforcing the covenants, that's not the primary purpose of a community association. And I have in the second bullet, generally, the purpose of an association is to promote community, however that's defined for that particular neighborhood. Now, let's say it's a private road community. Maybe promoting community primarily for that neighborhood or for that association is to keep the gates maintained if there are gates And by the way, you can have a private road community and not have gates. The gates are not what determines if something is public or private when it comes to roadways. But also other functions for an association for promoting community would be communicating, providing copies of covenants, providing information during the closing process, or educating the neighbors about the neighborhood, what amenities are available, what common areas are available for use of members. And then, of course, if there are common areas, the association is going to be the owner or the entity tasked with administering those. And sometimes it's something as simple as a green belt. Other times it's extensive drainage and very important to the function of the development, and that's how surface stormwater is diverted, contained, discharged, and that's a very important process, particularly in some areas of the state where you have a series of ponds or lakes, and they're catch basins, retention, detention areas. It becomes a very important function of the development and administration of those areas for the board to be familiar with how to administer those, how to budget properly, particularly if we have areas that are overseen by something called the Oklahoma Water Resources Board, OWRB, where you might have dams and spillways that are under OWRB oversight, but they're to be owned, maintained, repaired, insured by the community association. So knowing what those elements are is very important, and all of those elements are established at the outset of the development and initially maintained and overseen by the developer, but ultimately they're going to be um, taken over by the board that is elected by the lot owners. So what is it that creates all of these rights, responsibilities, obligations, this network or this patchwork of governing documents, we call them. And that's what this slide is. So I like to start with the plat, and I'll go ahead and show you. This is what a plat looks like, if you can see. So a plat is a function of statute, and it's going to have important information on it, not just the dedications page that will tell us whether we have public or private streets, whether the county has accepted those streets for public purposes. It'll be signed by a surveyor, the city county treasurer, if there is a county, or excuse me, a municipality, and a treasurer signing off. So it has a lot of this important information, but it also will have a page that looks like this, which is actually a legal description. This is what allows us to refer to lot, block of such and such neighborhood. And so this is the threshold document typically for most developments that have a mandatory association. Now, you don't have to have a plat to have a mandatory association. You could have meets and bounds or tract, plat of survey. You may have come across that a document with that title. But typically we're going to be looking at a plat, and the plat will answer whether we have a mandatory association, typically because in the notes section it will mention common areas shall be maintained by a property owners association comprised of the lot owners. That's very standard language that municipalities require. And even for plats in counties where you're not under a municipality, they often will still have that language about a property owners association or a common area. If you look at the center of this plat, I don't know if you can read it or not, but there is a circled letter C. So on a plat, lots and blocks, where houses will be built or intended to be built, those are going to be numbered lots and blocks. Blocks are circled numbers, and the lots are just an uncircled number in the middle of the lot. Circled letters designate common area. Now, different parts of the state do things a little bit differently. If you're on the eastern half of the state, Tulsa, Broken Arrow, Owasso, Jinx, Bixby, you might have what are called reserve areas as opposed to common areas. It's just a difference in terminology. On the western part of the state, Oklahoma City and surrounding metro area, you're going to see circled letters designated common area. And these are the areas that are to be owned by the association, maintained, and it's what uh, um, usually is the greatest expense and what dues or assessments go to pay for. So jumping back to our governing documents slide, some of the other documents that you might come across when either you're getting on the board or you just moved to a neighborhood or you're an individual in an association and you're wanting to know more about the neighborhood that you purchased into. These are the documents you're going to be looking for, and it's a great idea, again, whether you're on the board or not, to do the research and compile a governing documents file, whether you put it in a 3-ring binder or what, but knowing what the actual documents are that answer questions like, is there a mandatory association? Do we have a private road? What are the dues? How do we amend these documents? Can I put a shed in my backyard? Can I lease? Can I have backyard chickens? These documents are going to answer all of those questions. How do I get on the board? How often do we meet? Those are going to be answered by these documents. And that they include a declaration of covenants, conditions, and restrictions. And again, the title of this document is not so important as it is what the substance is. So sometimes you'll see a document called an owner's certificate. Sometimes it'll just be called a covenants, conditions, and restrictions. Usually it's a declaration of covenants, conditions, and restrictions. Sometimes you'll see a split where you'll have a document that's called a declaration of property owners association, and then you'll see another document that is called an owner certificate. And so now we have these two documents that we have to read together. Most commonly, more modernly, what you see is just one set of covenants and then a set of bylaws, rules, maybe design review guidelines, all attached to the same document. That document is going to be recorded in the county clerk's office where the real property sits. So if you have property in Oklahoma City, you might have your covenants filed in Oklahoma County, Canadian County, or Cleveland County because Oklahoma City is so large. If you are in Edmond city limits, probably Oklahoma County, and so on. So you might have to do a little hunting to determine where your covenants are actually filed. If your association is incorporated, and your association should be incorporated, if it's a mandatory association, there's nothing that says it has to be incorporated other than common sense and good risk management. But the articles of incorporation are going to be filed, if they are filed, with the Secretary of State. And the Secretary of State in Oklahoma has a great website if you're not familiar with it. You can go there, you can search for business entities. And if you're wondering whether your association is incorporated, typically you'll do a search for your property or your neighborhood name. So if your neighborhood is Happy Acres, you would go to the Secretary of State, run a search for Happy Acres, see if there's an association, and then you're going to look to see if that's tied into the name that's designated in your recorded covenants, right? And so that's a good way to determine whether your association is incorporated or not. One of the questions that comes up is, what's the difference between covenants and bylaws? Well, there are significant differences between covenants and bylaws. Covenants have to be recorded in the county clerk's office in order to be enforceable. Bylaws typically should deal with the business of the corporation. So membership rights, board elections, records access, common area rights, responsibilities for the association, duties and powers of the corporation kind of document. Now, it's a little confusing sometimes because in the covenants, we're going to have a lot of language about membership and common area maintenance and dues. But for purposes of voting, membership, those kinds of things, we're primarily going to look to the bylaws. Now, this is where there's a bit of a distinction between homeowners associations and condo associations, because under the law, if you buy a condominium, the bylaws have to be recorded at the outset. So with a condo, you're probably not going to have a plat, but you are going to have a declaration of perhaps unit ownership estate. That term unit ownership estate is what Oklahoma calls condos, whether it's residential or commercial, by the way. But also that same statute that requires the declaration to be filed to create a condo, it also requires the bylaws to be recorded. Now, other documents that we might be looking for, rules, regulations, I mentioned design review guidelines, corporate resolutions, any of these bundle of agreements, contracts that will help us navigate, okay, what is the association's responsibility and obligations? What are the rights, responsibilities, typically easements for the property owner? That's what we're looking to these documents to answer. So just rounding out the transition process. So we go through zoning, you get the plat filed, you get the covenants all filed, and then the lots are sold to builders, consumers, houses are built, and the development process just goes along until whatever the developer's plan is fulfilled. Now, sometimes that plan involves multiple plats and many phases of a development. So um, you might be looking at one initial set of covenants and then something called supplemental declarations. And those supplemental declarations are used to bring in those subsequently filed plats and lots into the whole neighborhood regime. And then ultimately, when all of the phases are done, when all of the lots have been sold, there's going to be a transition of control of the community association. Now, sometimes this happens around 75% of the lots being sold. Sometimes it doesn't happen until 100% of the lots have been sold. This is probably the first of several warnings about AI and the information that it sometimes gets wrong. So in many states, several states, I guess I should say, I haven't counted recently, but many states have adopted what's called the Uniform Common Interest Ownership Act, UKIOA for short. Well, this act provides some hard and fast deadlines when a developer has to transition control. We don't have that law in Oklahoma. So if you were to Google, when does a developer have to hand over control of the association, it's entirely possible that what's going to come back in your Google search or your AI search is this 75%. Well, that's not true in Oklahoma. It's only true if the covenants that were recorded for a particular neighborhood specify 75%. And that's not very common in Oklahoma either. I can't remember the last time I saw a set of covenants that said 75%. And all the ones I draft, they don't specify a percentage. It's a long period of time, or it's whenever the development period is over. Sometimes it's defined as the Class B control period. Class B referring to the developer interests. And that process happens according to either the specifics in the covenants or according to the developer's plan and when they're wanting to transition. But ultimately, there's going to be a time when it no longer makes sense, the developer doesn't have interest, or for whatever reason, there's going to be a transition of control from the developer sitting on the board, serving as the board, operating, administering the association, and the lot owners are going to take over. And we typically refer to that as a transition meeting. Really, the only thing that happens during transition is there is a board election and the former board steps off. That was controlled by the developer or the declarant. Sometimes you'll come across that term, the declarant. and then the lot owners will hold an election, and they'll be off and running and operating the association themselves. It's around this time, although possibly much sooner, possibly later after the transition meeting, the association will be deeded the common areas. Sometimes it makes sense in the development process, say there's a clubhouse or a swimming pool that's being built in the very last phase, and there's a handful of lots left in the last phase, but the clubhouse swimming pool is still under construction. We may have a transition meeting and the developer still involved with uh, building out those common areas. So it kind of depends on the development plan, the life of the development. Um, and Sorry, I'm reading a comment. I'll cover that in just a little bit. The question about leasing. So anyway, once there's a transition, that's really when the real life of the association begins. Clearly, developers are in the business of making money, a profit. That should not shock anyone. The developer, the declarant, is going to operate the association much differently than lot owners will. They're going to pick out different flowers for the entrance. They're going to maintain things differently, not better, not worse, just differently to suit their needs. And so once the lot owners take over, the board will begin the long-term, forever work of determining, okay, what is the personality of this association? What is it? What is the customer service or what is the community service that we want to provide? Um, I mentioned a couple of these. I want to hit a couple of more. A well-drafted set of covenants is going to have a definition section. Hopefully yours does, or if it doesn't, we will be talking about how to amend covenants, how to approve them throughout these 4 hours together. Um, One of the things to watch out for is a defined term not being used consistently throughout the documents or not being used at all. So for example, if you have the definition of visible from neighbor's property, visible from a neighboring lot, and it's never used throughout the document, well, we don't need that definition. Or we need to use that definition somewhere in the document. So that might be one reason to queue up an amendment. Um, and then also making sure that there's no duplication in the bylaws that creates conflict. So for example, if we have a definition section in the declaration and it defines the entire neighborhood as the property, and then in the bylaws we have a definition of the addition, and now we have some perhaps conflict of definitions. One of the things to look for definitions, the way we do this is we use capital letters for non-proper nouns. So the word property, the word addition, the word neighborhood, those are never capitalized except if we have defined them. So if you're reading through a document, covenants, contracts, bylaws, and you come across a non-proper noun that is capitalized, what that tells you is you need to be looking for that word to be defined somewhere. Usually it's at the head of the document. Sometimes there's a definitions section at the end. Sometimes we bury them right in the middle of the document, but hopefully it's pretty clear and well organized at the beginning, but using definitions consistently. I mentioned declarant class B. One of the common ways to distinguish between development period, developer control, developer actions is by using this class A, class B distinction. Sometimes you'll read that the class B member has multiple votes, 3 votes per lot, 100 votes per lot. Sometimes the Class B member, the covenants will simply say they control it until they sell all of their lots or until they relinquish control. But that's what it's doing in the covenants. If you've read that and thought, what is this Class B language? it's referring to the developer. Um, One of the important things to pin down, to determine is who controls the design review board, and I've got it as an acronym of DRB here, or the Architectural Review Committee, the ARC. Sometimes this will be described as building committee or architectural committee. However, it's named, it's talking about the same thing, and it's usually a three-person committee who oversees the structural applications or proposals from lot owners. So, for example, I have a house built and now I want to put in a gazebo or a pool. It's very common in these developments and in neighborhoods with covenants and mandatory associations to also have a design review board or an architectural review committee. It is not necessarily true that the association board appoints the DRB, the ARC, or serves in that capacity. Now, it is possible and likely that ultimately the association board is going to be in control of either appointing the ARC or serving as the ARC, but it's not necessarily so. And this is something to watch for and to read in your covenants, because and we'll talk about enforcement later, if your association is going to tell someone, no, you can't build that, based on the association serving as the ARC, we need to make sure that the association is in fact serving as the ARC, and the covenants are going to answer that question for it. It's not a mystery. All we have to do is read the language. And then the same thing for the HOA board. Um, just because the developer has sold all the lots and is no longer functioning as the HOA board doesn't necessarily mean that the persons who claim to be board members are the board. There needs to be an election, there's a corporate process, and the bylaws typically will answer that. I'm going to skip declarant rights unless there's a question about that and we can cover it. This slide gives you a bulleted list of where to find all of the statutes relative to homeowners associations in Oklahoma. So I have the Condo Act here, the I call it the HOA Act. It's actually the Real Estate Development Act, and there is some bleed over between that and the Condo Act. But in broad strokes, we have the Condo Act, which, like I said, is phrased or termed in Oklahoma the Unit Ownership Estate Act. But that means condo. Real Estate Development Act is at Title 60, Section 851, runs through 858. And then we have the Corporation Act, which, again, if your association is incorporated, then you're going to find important information in the corporation code. For example, if you have a set of covenants, it creates a mandatory association. You have an incorporated association, but you don't have a set of bylaws. For whatever reason, bylaws were never adopted. Well, the question becomes, okay, what's a quorum? What's the minimum number of people we need in order to conduct business? Well, if the covenants don't answer that, and often they don't, except for meetings to increase dues, then the corporation code will answer that. By the way, it's a third. So the corporation code answers a number of important questions if we don't have them specified in our bylaws. One of the questions, how do you determine when the transfer of the association has occurred when the governing documents haven't been updated since they were originally created 26 years ago, by the way? Well, here's a couple of things, because you're not going to find anything in Oklahoma law that says this is when a developer has to hand it over. There are some municipalities like Norman that have ordinances that touch on this. But what I would say is if a neighborhood has been in existence for 26 years and there's a question of corporate continuity, whether the current board, like I was saying, we don't have any evidence that the current board was elected. Well, that's really easy to fix. whoever is motivated enough can call a special meeting and hold an election. Uh, af Before we would do that, we would need to get our governing documents together, plat, covenants, articles of incorporation, try to find some bylaws, you know, scrounge the neighborhood, the people who've been in there for forever, and see if we can come up with our governing documents file. But ultimately, what we need to do in terms of transition is hold an election, have a duly elected board, and then they would proceed as the board of the association. Um, I'll cover this one. Is there anything in Oklahoma law that prohibits a neighborhood HOA from accepting gifts, donations from residents? Could this impact nonprofit status? I am absolutely not a tax attorney. I can't comment at all on tax issues. But in terms of associations accepting gifts, donations, they do it all day, every day in the form of volunteer, non-compensated board members. And so whether it's time, money, associations can accept those. Now, what the tax ramifications are for the persons making the donation, can't comment on that. I will tell you, I'm not aware of mandatory homeowners associations in Oklahoma that have common area that is used exclusively for its members that are tax exempt entities. Every association that we create is a nonprofit, non-stock Oklahoma corporation, but they're not tax exempt entities. And the only thing that would affect that nonprofit status, one, is filing articles of dissolution or conversion from nonprofit to a for-profit, or possibly, I've never heard of this happening, but I guess if a nonprofit homeowners association was actually being operated as a for-profit entity, I guess there could be some kind of enforcement. But it's there's not like this trigger that, okay, you've got this association who's organized as a nonprofit, non-stock, operating like normal associations do. They accept a donation either because of a budget shortfall or accept a donation of land, and now they're a for-profit entity. I don't think that's a thing. Um, so back to the law, Title 16 also covers a lot of real estate issues, primarily Title 16, Section 16. So one of the issues that comes up, and I hear this from attorneys sometimes, is, well, an individual doesn't have to comply with the covenants, or they're not a member of the association because they didn't get notice at closing, or no one told them that they were part of an association by virtue of buying property, or nobody gave them a copy of the covenants, or somebody flat out told them there was no association, but come to find out there were recorded covenants. Title 16, Section 16 covers all of that, and that is called constructive notice. So if there are duly recorded covenants on file when a person takes title to property within that neighborhood or subject to those covenants, then those covenants apply, whether they knew that there were covenants, whether they knew they were going to be a member of an association or not. And that's called constructive notice. So some of the legal theories apart, or a legal theory apart from constructive notice, is something called a common development plan. And that's another way of establishing that, look, we're not going to run down who knew what when, and then get to the analysis of, do the covenants apply to this individual. What we're going to do is apply either the statute, constructive notice, actual notice means they were provided a copy, or we're going to imply notice, apart from constructive notice, that there's this common development plan. And the way this works would be, if you drove into a neighborhood and looked at all of the roofs and they all happen to be weathered wood colored shingles, which, I don't know about your covenants, but it's very, very common to have weathered wood only shingle restrictions. And so if we drove into a neighborhood and there's just weathered wood shingled roofs, either the store was out of all shingles other than weatherwood color that day when we were building all of these houses, or two, there's something else going on. That something else going on is the common development plan. So that's another legal principle or theory that courts will use, and that's a very old theory in Oklahoma. It's been around for many years. So that typically don't have the issue of is this person subject to the covenants or not. I'm reading another comment here. Have you ever seen where a board member just does whatever they want, including approving their own architectural submissions? Um, uh, so if a board is serving as the architectural review committee, then they would have to administer their own architectural review submissions. There's a follow-up. I think what you're asking about, how do you handle conflicts of interest? And there's a really good way to handle conflicts of interest among boards, and that's whether or not we're talking about architectural review submittals. Most often when this comes up, you've got a board member who has a business and they can make a really good deal for the association, but that kind of rubs the non-compensated, no remuneration restrictions for nonprofit board members. So how do we deal with that? We don't want the association to have to pay more in the marketplace when they could get a better deal just because it happens to be from a board member. But again, we want to stay well away from self-dealing and nepotism, those kinds of things. So these are called interested director transactions. And the way you do it is you have a board meeting, you have full and frank disclosure of all the facts, you have competitive bidding, and say it's one board member who is the interested director, interested meaning they have the property that's going to be sold to the association, or they have the business that is going to make money off the association, or it's the president's daughter who is going to provide the catering for the HOA annual meeting, whatever the interest is. That director can serve for quorum purposes at a meeting, and they can even sit in the meeting. It's better practice that they serve as quorum for quorum purposes, and then they leave the meeting, let the board members have a full and frank discussion, and then the board members vote. So that's how you cure conflicts of interest and interested director transactions. All right. Okay. There was a comment up here asking about leasing restrictions. And I've got a couple slides on leasing restriction. I would say this is probably not leasing restrictions in general, but short-term rentals. This is since COVID, this is the number one covenant amendment that neighborhoods are doing. This is a very active area in the law. I know our firm has several um, cases up on appeal right now. We're just waiting for the Supreme Court to weigh in and tell us what the law is in this regard. But let's talk about leasing restrictions, and included in that will be short-term leasing. So the applicable governing documents for leasing restrictions, I've never seen one in a plat except for maybe one that was filed in the 20s, the 1920s, 1930s, maybe 40s. It would be a very old plat, possibly a leasing restriction. Most often, what we're going to see is some kind of leasing restriction along with other structural and use restrictions. And by the way, when I say use restriction, I'm talking about how a person can use their property. Can I open a saloon in my garage? That's a use, yes or no. If no, that's a leasing, or excuse me, a use restriction. Can I lease my property for long-term or short-term, whatever? That's a use restriction. Structural restrictions are How big does my house have to be? Can I have a gazebo? Can I have a swimming pool? All of that kind of thing. What kind of roof shingle do I have to put on? So use restrictions, structural restrictions, they either have to be in the plat, but most often they're in the declaration or the owner certificate. What we're going to find, if you're not already aware, is it takes a little bit of sweat equity, a lot of drafting, a lot of consensus building in order to amend covenants. It's not an easy process. It's an entirely doable process, but it's not easy. So what we find sometimes is people saying, well, if it's so hard to amend the covenants, we'll just amend the bylaws because bylaws are very easily amended. Well, you can't do that, not with structural and use restrictions. You can amend bylaws to talk about, taking away common area privileges for non-payment of dues, member in good standing provisions. That's really common in bylaws. You cannot put a leasing restriction in unfiled, unrecorded bylaws. Now, again, this is where there's a distinction between condo associations and other neighborhoods, non-condo developments. Because again, like I said, condo bylaws have to be recorded. So sometimes what you'll see is a leasing restriction in condo bylaws. That's perfectly fine. What you can't have is the traditional corporate type bylaws that have an enforceable leasing restriction in it. Okay. Um, and that's what I just covered. That non-condo bylaws, rules, whether they're bylaws, rules, policies, those kinds of leasing restrictions or use restrictions are unenforceable. Some of these other absolutely statements that I have on here, I'm not going to go into a lot of detail of why, but one of the things we don't want to put board members in is a position that is an undue taxation on their time. Boards usually meet once a month. A lot of board members will answer emails at all times. Sometimes that gets a little excessive and intrusive on board members' jobs, lives, personal time, all of that. Um, but we don't want board members in the position of vetting or determining whether some landlord's tenant is approved or not. That's not the role of an association board. That's a landlord's obligation. Also, background checks, that's the landlord's job, not the association. Now, sometimes you'll have an association that has a form to be filled out and it's contact information. Well, that goes for whether it's an owner occupant or a tenant occupant. That's perfectly fine. Let's talk about some varieties of leasing restrictions, and this will get, I think, to your question or comment about 30, 60 days. Um, and if not, hit me with another question. Um, uh, there is a comment about a House bill. There have been several House bills that deal with this, among other things, record keeping and some language about small claims actions. None of those bills have passed in the last couple of sessions. There's one that is, I think, dying or dead in the Senate Judiciary Committee. So again, this is another reason for drilling down. If you do a Google search and ask about leasing restrictions in Oklahoma, it might pull this or another House bill up. Another thing was with solar. For a while, we were having a lot of internet searches come up saying Oklahoma has a statute that prohibits associations from limiting solar panels, and that's absolutely false. We do not have a statute in Oklahoma that says that. There was a bill introduced, but as we know from the Schoolhouse Rock song, it's only a bill until it gets actually adopted into law. And that, whether it was a leasing restriction bill, solar panel bill, those have not been adopted. So right now, it is just up to what the covenants say. Again, with leasing restrictions, we have some activity at the appellate level, but nothing definitive just yet. We're hopefully going to get something like that soon. Let's talk about the varieties of leasing restrictions. So one very common, very old leasing restriction is actually not a leasing restriction. It's an owner occupancy period requirement. And so what this would look like is there a period of time when a person takes title to a lot subject to a covenant that restricts initial occupancy that requires an owner occupant versus buying a property and immediately putting a tenant in there? Usually we'll see these with some kind of mortgage product where VA, FHA, Fannie Mae, Freddie Mac, some kind of program that gives down payment assistance. There's going to be a provision that requires an owner occupancy period in order to keep people, investors, from buying property, getting cheap down payments, and then turning around and leasing the property. So those are common occupancy restrictions. And then we also have traditional leasing restrictions, 10%, 20%, whatever the covenant says. Sometimes what we'll see is carve outs where there'll be an owner occupancy requirement or a leasing restriction, and there's exceptions allowed for inability to sell a home, or it will define owner occupant as the title holder, their spouse, and then so many degrees of consanguinity. In other words, grandparents, parents, uncles, they will all be defined as owner occupant because the idea behind that is to encourage families to live together, families to own the property or occupy the property if the title holder is unable to live there in skilled nursing care or otherwise. So we see some of those provisions in leasing restrictions. It's very common to see language in a leasing restriction that the entire lot or the entire house must be leased. In other words, no swim or those kinds of arrangements where I lease out my swimming pool or my backyard for dog parties where you have um, people coming in and it's not my child's birthday, it's somebody's Great Dane who they're renting my backyard. That is a thing. You can limit that with covenant language. Sometimes the idea is, well, we need a total ban on leasing. We don't have any statute or case in Oklahoma that says that is okay or not okay. What we have in Oklahoma is a rule of reasonableness. And the concern with a total ban on leasing is zero is an absolute, and it's possible a judge will determine that zero leasing indefinitely without any kind of carve outs or stipulations or exceptions is unreasonable. So um, so the couple of questions here, and it's I think it's nibbling around the edges of, okay, well, with policies or with community standards, can you set terms for leasing? And the further away you get from recorded, clear covenant language, the thinner the ice is. So, for example, if you have a defined term of uh, community-wide standard, that's a very common definition that I'll use in my governing documents. I wouldn't interpret that to include the board to be able to say, okay, well, we're not going to adopt a policy on prohibiting leasing, but we're going to adopt a policy restricting it to 12 months or more. The, there has to be a fair notice, a reasonable notice in the recorded covenants that there's a time limit on leasing. or we have to get that information elsewhere. So, for example, in Oklahoma City, you have a clearly defined set of ordinances that says what a business is. And so if you have covenants that prohibit business, and in Oklahoma City, you're operating a home share business, and offering your property to lease for less than 30 days, Oklahoma City determines that to be a business. You have to get a business license. You have to pay business taxes. And so you might not have that term in your covenants, but you have the restriction on business, and then Oklahoma City um, supplies the time frame. You would just have to look at the municipality where your covenants are, or you could amend your covenants and just put all of that in the covenant itself. But policies, bylaws, where we're trying to um, get around having either state law, municipal ordinance, or clearly defined covenants governing whatever it is you're wanting to restrict, then we're trying to enforce an unrecorded restriction, and what we see are courts striking that down. This is a great time to remind you that each case is built on the applicable facts, the history of the parties, the applicable governing document language. And so taking one thing that you hear and running with it uh, may be completely off base. So for example, what you're going to hear in the last bullet on this slide is specific individual assessments or fines. What we have found is specific assessments, fines are very cost effective, uh, very measured way to enforce covenants, partly because they match what we know in our civil society, and that's with traffic fines. There are some things that don't require a lawsuit. There are some traffic offenses that don't warrant me getting pulled out of my car, cuffed, and arrested, and having to go through a criminal trial. What they do is they pull me over for the infraction. They give me a ticket. I have an opportunity to go challenge it, or I can just pay it. That's what we're looking at with specific or individual assessments. But simply because that idea is out there doesn't necessarily mean your association has the authority to do that. So just like what I was saying with leasing restrictions, we can't just decide because it's a great idea, because we want to, and because it's somewhat difficult to amend covenants, we're going to adopt a policy, or we're going to amend our bylaws, and now we're going to fine people and charge them money, much less file a lien against their property. That language needs to be in the recorded covenants. Okay. Um, I'll cover this question. I know it's on a later slide. There was a question about, are Oklahoma HOAs required to have open board meetings? If your covenants or bylaws require open board meetings, then the answer is yes. If the question is, does the Oklahoma Open Meeting Act apply to associations? The answer is no. If anyone's struggling with this, you can email my office. We have a memo I can email to you. But if you read the Oklahoma Open Meetings Act, there are notice requirements. There is an invitation to the governor to come to your meetings. The Open Meeting Act has nothing to do with homeowners association governance. There's civil penalties that apply if you violate the notice. There's nothing in the act to even suggest that it applies. And so it's not intended to apply. It doesn't apply. I have once, maybe twice in my career, read a set of bylaws that expressly required the association to comply with the Open Records and Open Meeting Act, and that was a mistake. And they amended that out as soon as we walked through the reasons why you would never ever have that apply to the association. So the answer to that is no. Um, The one about transparency, the president acting like a dictator, will cover something like that in good board meetings and practices later on. Um, some of these questions I'm not going to be able to cover. I'll cover some of them from a high level in the meeting slides, but you know, things like individual behaviors that people did or things that people say, we're going to cover general rules of civility and meeting practices, and so hopefully I will cover some of that. I'm going to skip these slides on the Oklahoma City ordinance on home share, uh, things like backyard chickens. That was a hot thing 5 or so years ago, maybe more. Uh, you look at your city ordinances and maybe it will provide some guidance. I do have a reference to Norman's ordinance on HOA registrations and and some of the very unique language in Norman city ordinances dealing with real estate developments. One thing that hopefully you've already heard, this was a convulsion that our federal government threw on us that last year that we never should have gone through, but that was the Corporate Transparency Act. If you hadn't heard, that has been permanently suspended for domestic corporations. You don't have to do the registration anymore. If you're like me and were terrified that someone's going to kick in my door because I didn't register my LLC, I went through the registration just like everybody else for my entity, but you don't have to do that anymore. So thanks for that. The unincorporated associations. I already said if you're unincorporated, you should be incorporated. Anytime you share money, anytime you take people's money, even if you're a voluntary association, you're not a condo, you're not a mandatory homeowner association, you're just a neighborhood watch or community gathering association, whatever it is. If you're taking people's money and putting it with other people's money, you should do so under a corporate charter. All right. So it's a $25 filing fee. Once you file a nonprofit non-stock, it's good until forever. It's not like the LLC annual registration, if you're familiar with those. There's just really no good reason not to incorporate. I'll go ahead and mention, I don't have this on a slide, but I come across this maybe once a year where an association has been organized as a limited liability company. You can have a nonprofit limited liability company. There's not a great reason to do so for homeowners associations or condo associations. I won't delve a lot into that, but forming an LLC creates an organization that is different, fundamentally different than a C Corp, a corporation. You have members, you have managers, you can have bylaws, but typically you'll have an operating agreement. There's typically language in those operating agreements about capital accounts. It just creates a lot of questions and complexity that we just don't need for homeowners associations. The corporation code, the nonprofit, non-stock sections work very, very well. They've worked for decades. So we just tend to stick with those and not use LLCs. All right, let's talk about some meeting practices, and I'll try to hit some of the issues that I saw in the questions comments about board behaviors. We're going to talk about records access. Um, I've I don't have a slide, but I've got some materials to talk about with social media. Anyone have a problem with someone saying something crazy on social media? Yes. Um, So, a couple of things that we want to do with our meeting practice. Obviously, we want to meet whatever the notice requirements are in our bylaws. We want to meet our quorum provisions. but some of the things that a board can do to encourage people to attend. And by the way, if you're getting 15%, even 20% of your members showing up to your HOA meetings, you're doing very, very well. Don't get discouraged. It's very common for homeowners associations to have about 5% show up at the annual meetings. And maybe that's good. Maybe that indicates everyone's very happy to just pay their money and let the board operate things. But some of the strategies to increase participation and ultimately perhaps some other volunteers on the board would be have the annual meeting at the same time, same place, provide a written agenda. This not only might encourage people to take an interest, but it also helps keep the meeting on track and not become this free-for-all discussion. Um, if you're a neighborhood that has a lot of families with children, I don't know if you've ever experienced this, if you've had a small child on an airplane, in a church service, a funeral, it's like there's this expectation that children don't freak out. I mean, we know that children do that. That's in their nature. They're children. And so one of the things boards can do is specifically tell parents with young children, you're welcome here. We're going to have a play area if you want, or at the very least, children are welcome here. Now, if children are welcome here, then we have to have a meeting where children are welcome. And that includes, or I guess excludes, adults acting like children themselves, screaming profanities at one another, making accusations, acting like we see or read on social media and in the comments to YouTube videos. These are meetings and they are somewhat social. It's not a city council meeting, but our society has slipped into this way of behaving and way of speaking to one another online and sometimes in person that may be why we're not having people show up to our HOA meetings. They don't want to go listen to people be rude to one another, scream profanities, or vice versa. And so, if we have board members who are engaging in that behavior, it shouldn't shock us that people don't want to serve on the board, that they have a bad taste in their mouth about the association, or that they don't want to go to the meeting, or that these meetings are unnecessarily aggressive and combative. And so if we have board members who are either by temperament or training or unable to maintain their composure, then perhaps we need to have somebody else running the meeting and those board members just sit quietly. So whatever that looks like for your neighborhood, and there are folks out there, Neighborhood Alliance, hint hint, who give really good trainings on how to conduct productive, great meetings. And so what I would suggest is go to their website, look at their other trainings, and see what's available out there to help. Let's talk about proxies. Since it's hard to get physical bodies to a meeting, or can be, the way you can get your quorum is with a proxy. Now, I'll tell you one red flag that I see, and I call it a red flag because when we have boards who are making it unnecessarily difficult to participate, that's a red flag to me. What we want to look for are opportunities and board practices that make it easier to participate. And one of the things I've seen sometimes is I had a case one time where there was an association president who was clutching unnecessarily to his power as association president. And one of the ways he was trying to keep people from taking over the board was claiming that proxies had to be notarized. There is nothing in Oklahoma law that says a proxy has to be notarized. A proxy can be written on a cocktail napkin in Sharpie. Proxy can be a text message, an email. I don't know where I fall on whether a proxy could be like a message on Nextdoor or some other social media. I don't know about that one, but email most definitely, fax if someone still has a fax machine. So under Oklahoma law, electronic proxies are definitely valid. So use proxies, use Zoom. People participating by Zoom. That's how business got done for a couple of years. Even in the court system, we had evidentiary hearings and motion dockets by Zoom or Teams or Blue Jeans, whatever the conferencing was. So we can have our HOA meetings um, online and get our quorum with proxies. Let's talk about board meetings. I've already talked about Open Meeting Act. The board needs to meet regularly. Now, forget about the Open Meeting Act. The question about whether board meetings should be open to members. And the answer is, in my opinion, yes. Of course, if the governing documents require the board meetings to be open, you have to follow that language. A lot of times the hesitation, fear, the problem with inviting members to board meetings is that the members come and they think this is a wide-ranging discussion and that it's a time that they can just call out questions or offer their 2 cents at any time during the meeting and demand that board members answer their questions. That's not the purpose of a board meeting, and I'm not sure where the idea comes from, but there is nothing in Oklahoma law or the bylaws typically that says board members have to answer every question that comes to a member's mind. And if you think about it, it could not be true that board members have an obligation. Sometimes you hear fiduciary duty. They have a fiduciary duty to answer my questions. No, they don't. That is not fiduciary duty. Fiduciary duty is a duty of loyalty, meaning don't steal from the corporation. And they have a duty of care, have board meetings, do the business of the board. That doesn't include answering every question, particularly if that question comes over 90 emails in a 2-month period from one member. Board members just don't have the capacity, the ability, or the obligation to respond to all of that. But sometimes that's what we see with members is just this incessant, what are you hiding? All of this stuff. And it bleeds over to social media, which I'll talk about in a second. But boards do have an interest in transparency. I saw that word in the comments, and I'll hit on that. Of course, board members have an interest in transparency. They're servant leaders. Their obligation is to do the business of the membership. And in order to do that, they have to know what the membership wants. So there has to be some kind of transparency, but there also has to be a recognition among the members that the board is elected in a representative capacity. Just like any elected official doesn't have an obligation to answer my emails or to vote the way I demand. So the threats of do this or else I won't vote for you. Okay. If those individuals making those threats or demands have better ideas, better stamina, more time, well, then volunteer on the board, just like your other neighbors. Don't get paid for it and do the business of the association. So sometimes what I find is board meetings become free-for-alls because board members have allowed that to happen and have encouraged this. Okay, we're just going to have this conversation, and maybe we need to rein it back a little bit into, okay, we're going to have a time at the end of the meeting for questions and answers. We'll try to answer as many as possible. If you could submit questions prior to the board meeting via email or whatever the portal is, then maybe the board can respond. But this business of, firing an email to a board on a Friday night, hey, what did we spend this money on? And they don't respond. And then 9 a.m. Saturday morning, somebody's on social media or next door saying, the board's not answering my questions. What are they hiding? Are they stealing from us? That is inappropriate communication, and it doesn't build your community. All it does is wear down board members, create suspicion, confusion, chaos. And that's sometimes what people go to social media and Nextdoor to do, is just to sow chaos. Well, boards have absolutely no obligation, no fiduciary duty, no time or inclination to respond to that kind of stuff. So it's a two-way street, is I guess what I'm saying. Boards need to provide an opportunity for transparency, putting all the books and records on a owner portal so that people don't have to ask, hey, where's the P&L? It's already there. Just go to the portal and find it. Where are all the bank statements? It's on the portal. Where are the meeting minutes? It's on the portal. All of those records requests are covered because we've already provided it. And then also providing time at board meetings for questions and answers. Or if somebody has an idea, the board needs that portal, that communication channel for getting all of those really good ideas. And maybe you have someone wanting to serve on the board or to help lead a committee, serve on the architectural committee, like we talked about. And so it is a two-way street. And the other side of the street is members have to be respectful of board members' time and the fact that they are non-compensated volunteers, and use the established channels of communication so that everyone is pulling in the same direction. Now, I'll hit one more thing, then I'll scan through the comments, see if I've missed any. Um, um, and that is, oh, I lost my thought. Um, it'll come to me in a minute. What I want to hit on are, I came across this list of social media do's and don'ts. And one of the things, and now I just remember what I was going to talk about, and that's fostering a culture, an environment of civility. So back to our dictator president. Um, Sometimes um, association presidents or boards seem like they're being a little too authoritarian, but sometimes that's required. Sometimes someone asking questions on social media or next door might seem kind of pointed, but they are asking the questions that need to be asked. All of that is part of consensus building. All of that can be uh, communicated and hashed out in a spirit of civility without questioning someone's morality, questioning someone's humanity, uh, questioning whether people like children or hate children. Getting evaluating whether to get rid of a swimming pool or a playground doesn't mean your board hates children. Okay. And so that kind of dialogue, that kind of discourse isn't helpful. And we need to help each other move away from that. Sometimes people fly off the handle and just need a gentle reminder to get back to normal civility. But we have to be on guard against that kind of communication, but we also have to be open and willing to hear whatever that minority dissenting voice is. All right. So back to social media. The things people used to get punched in the face for saying in person, now they say routinely online, and they think it's with impunity. Board members, individual members, however you can foster the conversation getting back to civil discourse, that is some of the best community building your neighborhood can do. It's not going to trickle down from Washington. Facebook isn't going to come up with a magic algorithm or moderation that's going to make people behave online, they're just not going to do it. It's going to come from the bottom up, and the association that you're in, the board that you serve on, or the association you're a member of, that's where it's going to come from. That's the bottom level. Okay. Um, on this list is don't make statements that are untruthful. You're entitled to express your opinion about many subjects, of course, provided they're factual. For example, you can express your opinion that the president of the association makes too much money. That's a joke because they're non-compensated. But you cannot say that they have stolen from the HOA. So this is a great example, and I see this incredibly frequently, that this allegation of embezzlement because the board's not answering financial questions when the records are freely available online. It's unacceptable. It sows chaos, and a lot of time that's just the purpose, is to create chaos. Um, if you have examples of an association board member or someone embezzling, well, of course, go to that person just like you would want that person to come to you and address it, and not go to the world, not go to the media and start making these allegations, because now we're all consumed with having to respond online, protect reputation. There are ways of communicating these things, ways of getting these issues answered without blowing things up. All right. So moving on, one of the questions: can the chair of an HOA meeting make a motion? Under Robert's Rules of Order, I believe the answer is yes. Under Matt's rules for homeowners associations, the answer is definitely yes. However, this comes up very, very rarely, I would say. And so if there's a problem with the chair making a motion, which, by the way, standard motion practice, someone makes a motion, the motion has to be seconded, then there's a period of discussion or debate, then there's a motion to close debate, motion to vote. That is a lot of formality for what normally goes on in a homeowners association and association meeting. So usually we don't have to, pick out whether chair can make this motion. Really, it makes very little difference who's making the motion. We want to get business done, and we want to make sure that everyone's on the same page as far as the process goes. So either you adopt Robert's Rules of Order, you adopt meeting rules, which the board can do at any time, and we roll with those. Question about voting electronically for bylaws, covenants, and/or elections. There are three different answers to that. Bylaws can be amended, and we'll get this later, but I'll give you a sneak preview. Bylaws can be amended unilaterally by the board itself, and that may crawl all over regular members, but this is Title 18, Section 1013. Board members, a board, can amend the bylaws. You can also have member bylaws amendments, and that vote can be done by electronic vote, except if we're talking about amending condo bylaws, which again is a separate animal. Covenants cannot be voted on electronically. And the problem is because they have to be, well, I say have to be. Almost always, sorry to sound like a lawyer here, almost always covenants have to be amended by a notarized ballot signed by a lot owner or the lot's owners. So exceptions to this would be if we have an amendment clause in a set of covenants that clearly provides for a corporate type vote. Then it's possible that you could do an electronic vote. I've never done one for covenants because it's an electronic vote for covenants, because almost always it's a notarized ballot. Elections, absolutely, and should be encouraged to vote electronically, again with proxies. comment about AI as the answer to civility. I read a horrifying article recently about the confirmation bias that AI has. So whatever crazy thing I spew into it, it's just going to feed that back to me and confirm it. AI is really good if you are polite to it, saying please and thank you, and asking, I'm having difficulty communicating with so and so. I want to speak to them the way I would want to be spoken to because that's just the way we should operate in the world. Can you help me think of ways to approach this difficult topic? My neighbor's kids are driving me crazy. Their dog's barking all the time. I really value my neighbor, like almost like I value myself. These are things, this is the prompt that you're giving to AI. What you're going to get back is a fairly useful, typically script or ideas. Um, so that's a great way to use AI to promote civility. It's also I'm getting wild demands from individuals who clearly have used AI to try to put the screws to their association or board, and it's not helpful. There's a question about a board member holding access rights to social media, to Google, things like that. So if something is created in the name of the association, or if the association creates a web page, pays for the GoDaddy, Network Solutions, whatever name, it doesn't matter how much time a board member or a volunteer or a manager or a lawyer has put into that product or that thing is the property of the corporation. And because someone gets thrown out, because the lawyer gets fired, whatever, the management gets moved on and a new manager comes in, you don't get to hold that the passcodes, that property hostage. It's the same whether it's digital, whether it's physical, it's all the same. It's called conversion. And the corporation, the association would have a cause of action against that individual for recovery of those items. So the answer to that is they don't have the right to do it. You would ask them politely once, maybe twice, and then the demand would be return it. Otherwise, we'll ask a judge to do it, plus any damages, attorney's fees, and costs. Let's see. Are you saying each vote must be notarized, or the ballots as a whole are notarized? Each individual ballot for a covenant amendment project would be notarized. And we do go into much more depth in part 2 about this, but it's the individual lot owner's signature that is notarized, not just, hey, we took a vote, we got our percentage, and the president signs, and the president's signature is notarized. The only time covenants can be amended on that procedure is if the covenants are abundantly clear. That's how you do it. I mean, specific that the amendment is signed by the president, acknowledged, and recorded on that officer's signature. It has to be very, very specific. What about board transitions, difficulty getting old board members to turn over HOA records, property, use of lease space? Same thing. It is a conversation, and we've seen this at the White House. We see it, every 4 or 8 years when there's a transition, and we hear about those administrations who are helpful to the new administration coming in, even if they're an opposing party. It can happen. You have these people who are, sworn political enemies, and they don't magically lose the keys or make it difficult. They do the respectable, professional, civil thing, and they have a smooth transition of power. We can do the same thing with our boards. If they don't, the courts are always open, and Judges, I can tell you, are nonplussed with adults throwing tantrums because they got thrown out of office or they want to make a point by converting someone else's property. But the courts are open for adjudicating that. All right. One of the things that I want to talk about with this slide is meeting minutes. So our practice sometimes involves litigation. And if that litigation revolves around, well, what did a board do? Or what did they authorize? Or what happened at this meeting? Maybe there's a difference of opinion on whether this board was elected or not. We're going to look at meeting minutes because meeting minutes are what's called prima facie evidence. That just means on the surface, on the face of it, if we have meeting minutes, well, then that's what a court is supposed to go with. That's what the law says. Now, that's a rebuttable presumption. So, for example, if I have a meeting minute that says we had a quorum, that we did this and that, but there's a video out there that says, shows the room and clearly we didn't have a quorum, well, maybe the presumption can be rebutted. But every meeting, whether it's annual or board meetings, need to have some kind of meeting minute. Now, one of the things that I find that burns board members out or officers, typically the secretary, and that's this idea that meeting minutes are a transcription of everything that went on at the meeting. Well, Matt said this, and then Mary said that, and Matt thought that was a great idea and voiced his support. That's a transcript. That's not meeting minutes. Meeting minutes is, was there proper notice given? Where, when was the meeting? Did we have a quorum? Maybe there's a sign-in sheet to help establish quorum. We attach all of the proxies. If they were emails, you print them off. If they're text messages, you print them off. If it's a Zoom meeting and we have 100 people, then you record the meeting and possibly have every person identify themselves in the comments just so that we have a record. But the meeting minutes establish that there was due notice, that there was enough people to do whatever the business was. And then it is, if you do motion second and vote, it's going to identify that. Otherwise, it just records the bare bones business that was conducted. And then there's an adjournment. That should immediately be scanned. And when I say immediately, of course, meeting minutes have to be approved, which that would be at the next board meeting, or boards can conduct approvals. This is called a consent in lieu of meeting. If you circle the meeting minutes or circle any kind of proposed decision and you have unanimous board approval, that's called a consent in lieu of meeting. And they can adopt those meeting minutes, or they can approve this vendor or this contract or whatever. And then those get saved in the corporate records. Ideally, again, put online somewhere where individual owners can find them without having to ask the board. But that's going to be what happened. That's the record of what happened at the meeting. I will tell you again, back to AI, Zoom has a great function, AI assistant. Zoom can also record, and then you can make a transcript of the meeting. It's not 100%, but if you have an AI assistant, a summary of the meeting, it's gonna look a lot. Actually, it's gonna be more robust than typical meeting minutes, but it's going to record who made the motion, the second, whether there was a vote, what kind of vote it was. And then if you have a video along with it, we have really good record keeping of what happened at the meeting. So great question about executive session. So what about executive session? Well, corporation code's not going to give you any guidance on executive session. Hopefully your bylaws will say something about it. But executive session is a means for a board to have a full, frank, candid, sometimes confidential conversation. It is not a technique to just throw everybody out of the room so that you can, talk about what you want to talk about. It's a very specific tool. So, for example, if a board needs to meet with me and talk about a collections case or an enforcement case, or for an employment, this doesn't come up very often with associations because most associations don't have employees. But if there needs to be confidentiality with an accountant or a civil engineer, possibly an attorney, then maybe you go into executive session. Executive session is just this protective communicative cloak that the board can feel free to say whatever needs to be said. This is one of those areas where that dissenting, that minority voice really needs to be heard. Even if it seems like everyone's on the same page, think of the 12 Angry Men, somebody asking questions and getting down to the truth. Sometimes it takes someone with a little courage to say, well, wait a second, push against the cut against the grain a little bit. But whatever the product of that conversation is, whatever the action that's going to be taken, that comes out of executive session, and then there's a motion, a second, or the board takes whatever action. We don't have to rehash, and we do not keep minutes of executive session meetings. Some associations do. If you do keep those meeting minutes, they are discoverable in litigation, and I would encourage you not to do that, but I know some associations do. So typically don't keep meeting minutes, and that's the purpose of an executive session. What if an association has no minutes? Have you ever heard of no meeting minutes because of no quorum? Absolutely, because if you don't have a quorum, you don't have a meeting. If you don't have a quorum, you're not conducting any business. You're just having an information meeting. I suppose you could keep minutes of an information meeting, but they're not really minutes. It's just somebody talking, and so it's not an act of the board. It's not anything enforceable for the association. It's just talk. So that would be the equivalent of a running discussion on Nextdoor or on social media or Facebook. So if you don't have a quorum, then I wouldn't think that there are meeting minutes. The question about what are reasons for not having meeting minutes, I can't answer that. I don't know why someone would have a meeting with a quorum and not keep meeting minutes. I can't answer that. I'm going to skip over. I mentioned that if you're incorporated, you don't have bylaws, you don't have applicable language in your covenants, that the corporation code supplies various default rules. Quorum, majority vote, plurality versus cumulative voting, minimum of notice. The corporation code will supply all of that, but we can avoid all of those default provisions by simply having a well-drafted set of bylaws. So I talked about quorum. If you're unfamiliar with quorum, it's simply the minimum number of people that you have to have in the room, in person, or by proxy in order to conduct business. You can have a quorum established, say, for example, if your quorum is a majority, which, by the way, a majority is not 51%. A majority is 50% plus 1 plus 0.1. It is whatever the next greatest over 50% is. So say, for example, you have a 50%, a majority quorum provision. We have 100 people and we have 51 people show up to the meeting. We have a quorum. Well, what if right after roll call, the meeting gets going and you have 5 people leave the room? Under the traditional understanding application of quorum, if you hit your quorum, even if you have people leave, you will still have your quorum. It's just, did you initially hit the threshold? All right. Now, ideally, your bylaws are going to say that, but that is the common law rule. So, um, I will say too, if there are contested director provisions in the corporation code, um, judges, at least it's been our experience, really do not like having to oversee homeowner association or condo association board elections. They'll do it because the statute requires them to, but oftentimes what they want to see is people working this out. And it's really easy to work out. People can absolutely hate each other and still play checkers because the rules are very simple. Um, as long as you don't cheat and as long as we are all playing by the same rules, you can be a sore loser and you can absolutely hate the guts of the other person, but you will be able to play checkers. It's kind of the same thing with elections. You can think that the other side's going to try to steal the election. You can be on your guard, but as long as we agree to the guardrails of the procedure, proxies, quorum, notice, well, then that's the democratic process. It's whoever, you know, ballots the best or whoever collects the most proxies is going to win. But ultimately, if you can't agree, there is a procedure for under statute, under the corporation code, for a court to oversee an election. I talked a little bit about proxies. Proxies must be signed or have a signature affixed to writing. Oklahoma law says electronic copies are acceptable. Electronic proxies are acceptable. So emails, text messages, all of that. If the proxy itself doesn't say how long it lasts for, so for example, I send Mary a text message that says, "Hey, I'm not going to be able to make the meeting tonight. I'm going to give you my proxy for quorum and voting purposes at this meeting only." Well, what I have done is I've given her my proxy. It's durable just for that meeting, and I have told her she's going to count for me for quorum purposes, and she can vote however she wants. She's got my vote. That's a very broad proxy in terms of voting, but it's very limited in duration. And we can modify that however you want. Oftentimes, the board will send out a proxy form. If, say, we're voting on, do we want to put in a new playground? Do we want to spend X number of dollars on this or that? You might have a line item ballot and proxy so that people get to vote on whatever the measures are. And then they can also they can cast that ballot and not have to show up to the meeting. Or maybe it's important enough to me that I want to show up to the meeting. I want to hear the debate. I haven't made up my mind yet how I want to vote. Well, maybe I don't want to execute a proxy. Maybe I want to show up and participate. Question about, can a landlord assign their proxy to their tenant? The answer is yes. So for corporate purposes, you can give a proxy to anyone, and that is pretty common where a landlord will give it to their tenant, particularly if they're a long-term tenant. What you cannot do is give a proxy for a person to execute a covenant amendment ballot for you. You can, but that proxy is called a durable power of attorney, and that durable power of attorney has to be executed with the formalities of Oklahoma law, and it has to be recorded with that ballot. So there again, when we're talking about corporate events, elections, budget approval, those kinds of corporate events, proxies are great. Proxies do not work with covenant amendments. Let's see. The question about your proxy gathering process ignored by the dictator and advice. I can't give any legal advice tonight. I can't comment on specifics like that. So I'm not trying to duck the question, but there are so many variables What is the governing document language? Um, were there deficiencies in the proxies? I don't know any of that and can't answer the question. Definitely can't give any legal advice. Um, here's another slide on electronic voting and email. We've already covered that. Oh, I did not cover this newspaper rule. So this kind of goes back to the way we talk to one another on social media. There's another item on this social media civility rules list that I have, and that's remember the internet is fleeting in terms of people's attention spans, but the materials are forever. The news cycle runs at the blink of an eye now, but that tweet that you sent out about, these scumbag board members, it's going to be there forever, right? And so having the presence of mind to not mix alcohol and your social commentary, that's a good idea. It's also a good idea, board members, to use GroupMe, social media, emails, as if everything that you're putting in there is not private, that it's going to be blown up in a very large exhibit in front of a judge or a jury, or it's going to be attached to a pleading, or it's ultimately going to be disclosed to the person whose yard you're commenting about. So, limiting the personal commentary, absolutely never using profanity, derogatory terms. That is just an invitation for trouble and doing serious destruction and chaos to the board's ability to lead. Um, So elaborate on the last point. Electronic voting is allowable in Oklahoma law, may require governing document amendments. So what I'm saying is there are some bylaws that, say, for example, bylaws has language that says proxies shall be in writing and delivered personally to the secretary prior to the meeting. All board votes shall be by secret ballot. So if we have some of that language in our bylaws, we don't want to have to litigate or navigate the questions of, okay, well, Oklahoma law says electronic notice and proxies and voting are perfectly fine. Do we have a valid election if we do that following Oklahoma law, but we have this language in our bylaws? That's what I'm talking about. It's really easy to amend that bylaw language. Just have at the next board meeting, um, except as otherwise provided by law, ballots for elections shall be by secret ballot. So what that does is if we want to use secret ballots, we can. Sometimes secret ballots are fine, but again, board elections are not state secrets. And if someone is that concerned about who they're going to vote for, I think there's something else going on. I'm hard pressed to come up with a circumstance where me voting for Jack or Jill needs to be kept secret. All right. And I get it. I've been doing this for 25 years. I've been through some very contentious meetings where fistfights break out, screaming matches, law enforcement called, all of that. So I doubt that any meeting that anyone on here has experienced, unless there's been an actual shooting, has been more contentious than what I've seen. Out of all of that, um, we have to let the democratic process work. And when things get to that level, that people are fearful of someone knowing how they voted, we have so much other work to do in getting the temperature down, getting people back accustomed to at least agreeing to what the ground rules are and not being fearful of, okay, my house is going to be destroyed or my car keyed or someone's going to defame me on social media because they found out I voted for Jill as opposed to Jack. All right. So, but if you have to have secret ballots, then so be it. Um, some of these frequently asked questions, they have come up. Some of them have, others have not. So one of the safeguards I've seen in the comments and mentioned a couple of times about dictators or uh, tyrannical board members or presidents. So one of the safeguards that we have against that kind of behavior, apart from going to that individual and saying, "Look, Jack, you screaming profanities at our annual HOA meeting is kind of polarizing, and it's rubbing people the wrong way. Is there a way you could tone that out?" Going to that person, seeing if the behavior will correct itself first. But if that's a complete dead end, um, you can always remove board members. There are provisions either in the bylaws or under Oklahoma law for calling a special meeting and having a removal process and putting someone else in that position. Um, the board member that I mentioned earlier about requiring notarized proxies, that's exactly what we did. A group of owners had just had enough. They collected proxies sufficient to call a special meeting, and that individual was removed. Now, that individual, if they want to challenge the special meeting, if they want to challenge the election, again, the courts are open to them and they can convince a judge that they are entitled to stay in power. Um, but there is always the right to remove and call a special meeting. So um, that's that's a consideration. Let's see. I've talked enough about social media. I will mention this because I think it's an interesting thing to think about. If you're not familiar with the concept or the doctrine, I guess, of the tragedy of the commons. So the tragedy of the commons, it refers to shared pasture land, whether cattle or sheep. And the idea, the tragedy of the commons is if there is this resource that I can gobble up for my own uses as much as possible, then what happens is everybody acts in self-interest and you destroy that thing. Because if you're not aware, overgrazing turns the grass to dirt and no animal gets fed. And so one of the things that I think is important to keep in mind, particularly as we build civility individually in our own behaviors, and then also try to encourage civility in others' behaviors, is this idea of, okay, if I take, if I have to get that last word in, if I'm going to make sure that person feels exactly how angry I am, if I am going to impress my opinion and then some, however you want to phrase that, um, what I'm engaging is the tragedy of the commons, as opposed to, okay, I have something important I think needs to be said. I don't feel like I'm being heard. How can I create an environment or how can I encourage this person to listen to me? I don't know about you. My ears close up when people are insulting me or if they're belittling me. Um, they also close up if people are pandering or flattering me. Now, if they're being nice to my children, you got my ears. So that's the tragedy of the commons when it comes to social media. If all we do is scream, no one's going to hear anything. Nothing's going to get done. We're going to be a people of chaos as opposed to a people of civility getting really good community building work done. So that's that. All right. I'm going to, in our 7 minutes, I cannot believe it just flies by. Talk a little bit about enforcement. So a lot of times people want to know, okay, well, what teeth do the covenants have? And how do we enforce these things? So a couple of the considerations there is, number one, is your association even authorized to enforce the covenants? So for example, you could have a mandatory association and you could have this laundry list of things that people have to do or should do. Um, and then you come to the enforcement clause, and it says any lot owner aggrieved by a covenant violation may bring an action in law or in equity. It doesn't say anything about the association. Is your association authorized to enforce them? That's a question. Second question is, does your association want to be in the business of enforcing this particular thing? Board member, you get an email from an individual that says, my neighbor's dog is driving me crazy. What are you going to do about it? Almost always the appropriate response is, I'm going to encourage you to go talk to your neighbor because it's your responsibility, not the board's responsibility, to go talk to your neighbor about their barking dog. Now, there are issues that it is the board's responsibility. Someone not paying their assessments like they promised to under the covenants. Someone operating a business that's affecting the surrounding neighbors. Maybe those are things that the board would become involved in. Someone constructing the Taj Mahal of RV sheds in their backyard, or the man cave or she shed, whatever they're building. Maybe that's the association's jurisdiction, but asking the question, is this the association's job, or is it of such importance to the neighborhood as a whole or to a significant portion that the board wants to become involved? It's also an important question, if the association becomes involved from a litigation standpoint, is there a pathway to attorney's fees? And these are all questions that you evaluate before you head down the road for enforcement. I'll show you this picture. We all recognize what that devilishly handsome royal is doing, right? He's showing his American displeasure with someone, except we're looking at it from the wrong angle, and he's actually giving it the British three, not the American hello, right? So this slide is just an illustration. When it comes to enforcement, and I am this way, I have a bent to jump in. Where did they go wrong? Why aren't they doing this? All of that kind of trails on getting notice that there's this violation. One of the threshold questions, though, is, okay, could we have this wrong? Is this email from the individual complaining about the neighbor's dog really something completely different? Is it a dispute over a fence that may have been instigated by the person making the complaint? We have to keep all of that in the realm of possibility, and as a board, instead of just jumping in and picking a side, right? Last thing that I'll say about enforcement, too, is enforcement starts long before there is a alleged covenant violation. So the best enforcement action is one where we have created a situation where a board member or a neighbor can go to someone else, have a conversation, and convince them, whatever the issue is, to do what that person or the board thinks they should do. That is the most successful enforcement action. So I'll give you an example. If I'm buying property in a neighborhood that has weathered wood only shingle, and I've never owned a home before, and I have no idea that there's this thing requiring that I put this brown colored shingle on, it would be helpful not required, but helpful that someone put that in my hands and possibly with a summary sheet that says, hey, Matt, now that you're a homeowner, number one, we are so glad that you are our neighbor. Number two, these are some of the important things you need to know about our neighborhood. It's no coincidence that all our roofs are brown. It's because we have this set of covenants that says. So what you have done possibly have avoided an enforcement action where I don't have any concept of this and we get a hailstorm and now I'm putting a black shingle or a gray shingle or heaven forbid an OSU orange or an OU maroon, excuse me, crimson uh, shingle on my roof. So the point there is with this upfront, welcome to the neighborhood, good communication, combined with a culture of civility and good communication, we can avoid paying lawyer fees. We can avoid getting to that crossroads of, all right, we're either going to have to go to court or we're going to have to just, accept this. So that's what I mean by enforcement starts before closing. We will talk about enforcement in much more detail. This ever persistent, well, are we waiving covenants? How the selective enforcement, what's arbitrary and capricious, all of that. We'll talk about that in part 2. So have a good couple of days and I hope to see you on Thursday.
Thank you, Matt. I always learn so much from you. Just a reminder, we will be using the same link on Thursday. Have a good night.
Okay, well, welcome everyone back for part 2. Also want to welcome Matt Thomas, attorney colleague of mine at Winton Law, and he is here to correct all the stuff that I get wrong. He's going to jump in and make sure that the information's accurate. So I have my minder tonight. We were kind of freewheeling it last time. So anyway, I am going to share my screen like last time and give me just a second and we'll get this going. All right. Well, I was peeking at some other stuff, so let me get this back where I want it. Arrange my screen, and then we will be in business. All right. Okay. So I'm going to skip the introductory stuff. Just reminder, this is an education conversation. It is from a very high level. It is definitely not legal advice. So don't take something you hear from part 1 or part 2 tonight and believe it is directly applicable to any situation that you have. You would need to evaluate the governing documents, the law, the facts, and those affect every case. Speaking of law, I didn't mention it last time. Um, I did have this slide, and I'm not going to go back over it, but I didn't mention, I hear this sometimes that, well, such and such happened in the neighborhood across the street from us. Therefore, that's going to happen in our neighborhood. And that is not, that's called a non sequitur. It's not necessarily true. The law isn't what happens in the neighborhood across the street or in the next county. The law isn't what your brother or sister-in-law read on the internet and tells you what the law is. The law is either a statute or a reported case by the Supreme Court of State of Oklahoma or the United States Supreme Court, or in some instances, a Court of Civil Appeals opinion whose publication of that opinion has been approved by the Oklahoma State Supreme Court. So just because we hear something, just because something might be true in another context, does not necessarily mean it will be true in your neighborhood or uh, in respect to your covenants. Where we ended last time was we started talking about enforcement. And I was making the point that enforcement, if you want to call it that, begins before you contact a lawyer, before you go to court. It is setting the stage for positive, successful results, whether that's a collections case, neighbor disputes, um, or enforcing structural and use restrictions. And then sometimes enforcement simply looks like providing an education or information and serving the individual. There are plenty of people who purchase a home, their first home is in a homeowners association, and they have no idea that they owe dues. Those folks typically do not need a lawsuit or a lien. They need an education and some help getting square on their account. We're not talking about excusing bad behavior or not doing what the covenants require people. That's not this conversation. It is treating our neighbor the way we would want to be treated if we were getting surprised by covenants or a collection and looking for some help from the association, getting them out of that situation. And in fact, that's how we approach collections cases. We'll talk about collections here in a second. We do a considerable amount of collections for HOA and condo debt. So we do have several slides on that. All right, next slide. Some things to think about when it comes to enforcement, because oftentimes um, or sometimes, I guess I should say, board members think, well, the language is on the page, therefore we have to enforce it. But the board is vested with what's called business judgment. The business judgment of a board is, do you buy mums for the front entrance, or do you buy petunias? Do you buy annuals or otherwise? Shrubs, bushes, trees, that's all business decisions. Whether to file a lawsuit and hire an attorney, whether to go to small claims court on your own and enforce the association's collections rights, that's all business judgment. And it's entirely okay for the board to decide, you know what, we're going to continue working on this and give them more time to try to get this right, or that the board doesn't have the money. The association simply doesn't have the money to litigate it, because anyone who's been involved in litigation knows that most of the cases that go to court, definitely the ones that go to trial, they can get very expensive. And the association um, needs to have a funding mechanism and know that they can go the distance on the litigation. That's where these bullets about relationship is less expensive and more certain than litigation. This isn't about touchy-feely, again, letting people get away with things, but it certainly is a litigation and economic reality that if you can convince someone to do what you want them to do or think they should do under the covenants or whatever the circumstance, it's going to be less expensive than hiring a lawyer and going to court. Now, it is certainly possible and true that some of the cases that we litigate, we go to trial, the association spends a lot of money and they recover all of that money, plus getting the relief that they were asking for. But it's not necessarily true, and there's no lawyer that can tell you you're going to win and get all of your money back. There's just too many variables for any attorney to make that guarantee. Also, the fact that an individual subject to the covenants, an HOA member, is telling the board, look, there is a covenant violation going on, you have to do something about it. The board not only has business judgment, but they also have a subjective determination or opinion on what could be a covenant violation or what is a covenant violation. And the fact that one neighbor thinks the neighbor's grass is too long, the board could reasonably have a difference of opinion. Simply because someone demands that the board do something under the covenants or believes that there's a covenant violation going on, it doesn't necessarily follow that the board is bound to do that, or that the board is somehow breaching their fiduciary duty because somebody's prowled the neighborhood and they see half a dozen trash cans sitting out. That works just like, the logic of, well, I pay my taxes. The taxes fund the U.S. Army. Therefore, I can command the U.S. Army to destroy my enemies. It just doesn't work that way, either with me in the Army or with an HOA member paying their dues and making demands on the board. Right? But there are some times when discussion, relationship, they simply don't work. And it takes two to settle. And when there are not two who are ready to settle or resolve the dispute or at least agree to narrow the issues, whatever it is, then it may be the association needs to take the next step with enforcement. By the way, I'll go ahead and say this. Um, One of the reasons why board members aren't bound to jump or to pull the trigger on an enforcement action simply because an HOA member demands it is because every HOA member has the ability to enforce the covenants themselves. So, for example, if there is a covenant that says no noxious or offensive activity may be conducted in the neighborhood, or that is an annoyance to the neighbors, that's a noxious or offensive activity um, covenant. And if a neighbor demands that the neighbor's barking dog be taken care of under that that nuisance covenant, the board can respond, look, we're not in a position, either time, money, whatever, to address that. And you lot owner can certainly move forward and enforce that yourself. So just because a lot owner wants the association to spend its money doing enforcement doesn't mean that that lot owner is somehow deprived from enforcing the covenant themselves. So, with that said, if the board's moving forward with an enforcement action, there may be a due process, what's called due process clause, either in the covenants or the bylaws. And that's what this slide addresses. If there is a due process clause, sometimes it will provide that notice must be served in a certain way, certified mail, but usually these kinds of clauses, they're talking about some kind of notice, some kind of opportunity for comment or a hearing. You see this bullet about en banc. That simply means with having a hearing or a meeting with the entire board. And the um, these clauses typically will require an individual within a certain period of time to make a request for this due process hearing. Some clauses are very specific and provide that the individual may show up with an attorney, that they're to present evidence and the reasons why the alleged violation didn't occur, almost like a mini hearing or evidentiary hearing or trial. Sometimes they're just very informal and having a conversation. But it's an opportunity for the person who has the purported covenant violation to convince the board that there doesn't need to be an enforcement. And so either the individual can be successful and persuasive and convince the board to do something, or they can't. Ultimately, the board makes the decision. And this is a formalized due process clause that you would find in the covenants or the bylaws. By the way, again, if the issue is between two neighbors, then the two neighbors could do the exact same thing. They could meet, have a conversation, see if maybe they were talking past each other, resolve it, and if not, then they're free, just like the association, to move forward. So I have a couple of slide pictures here just to demonstrate sometimes why associations or neighbors will make the decision to take the next step and go to litigation. Here we have the perpetual bulk pickup in the front yard. This is one in Oklahoma City from several years ago. This is a gem from Florida individual. I think substances were involved with him painting his house and his face. The waking up and finding a multicolored house, or just a single very pink house. This was, I believe, in Houston. This is a photo from a case we had in Tulsa where it's a great example of two individuals that were talking past each other. This was a board who was convinced they had the ability to assess monetary penalties, and the individual they were assessing them against disagreed. Turned out that they were talking past each other, and we were able to resolve that issue without litigation, thankfully. But we got a really great picture, and the individual that owned that property, showing his disgruntlement with his association, had this creative planter. So let's talk about some of the remedies that an association would be looking at in going to court. That's what we call judicial remedies, as opposed to non-judicial remedies like mediation, arbitration. But judicial remedies are when someone's going to court and asking a judge, uh, sometimes a jury, most often cases, these kinds of cases are judge cases, bench trials, in other words. Um, these are the various claims that at least our firm typically will litigate. There are any number of other claims out there that a person could litigate, but within the homeowners association, condo association context or realm, typically you're talking about collections of assessments or fines. Those sometimes are in small claims court. They can be in district court. In Oklahoma, there are jurisdictional limits to small claims court, which is 10,000. You might be in CS court, which is civil special, if the amount is under 10,000, but it involves some other kind of remedy that you can't get in small claims court. For example, by statute, you cannot get an injunction in small claims court. You would have to file that in CS or CJ. So any dollar amount for damages, collections over $10,000, that's going to be district court action in CJ court. All injunctive cases, so an injunction would be um, make the pink house look like every other house in the neighborhood. If that's the relief that a litigant is asking for, then you're asking for a mandatory injunction from the court, and that must be brought in district court. Another kind of injunction is a prohibitory injunction, and that would be asking the court to prohibit someone from doing something, operating a business, proceeding with some kind of construction project in violation of the covenants, asking the court to make someone stop doing something. Anytime you're asking the court to make someone do something, that's mandatory. And oftentimes you're litigating, uh, asking for both of those in the same case. Other cases, there might be a nuisance if there's something that's of a particular annoyance or creating a loss of use and enjoyment to one or more neighbors, then there may be a nuisance. For a nuisance cause of action, and by the way, there can be a general statutory common law nuisance cause of action, or it can be based on covenants, that noxious or offensive or annoyance language that I mentioned earlier, if that's in the covenants. The traditional remedies for nuisance is either abeyance, which is in the nature of an injunction. We want the court to abate the nuisance. That means make it stop, or damages. There are damages available for nuisance. And then lastly, what I have on here, the kind of cause of action that one might find in an HOA or condo context is declaratory actions. And that's I have honest disagreement here. There has to be, the statutory term is actual controversy. Courts are in the business of providing advisory decisions, or hey judge, we were wondering about this, can you give us an opinion? Courts aren't open for that, but they are open for actual controversies, and that's called a declaratory action. So uh, once again, before we run off to court, remember our royal friend and the importance of at least considering that maybe there's another side to this, maybe there's a perspective, maybe that is simply, have we run the numbers of what this is going to cost? Is there a pathway to attorney's fees? Is there an opportunity to convince the potential defendant to join the rest of their neighbors to do what they promise, sometimes expressly, under the covenants, to stop doing or start doing whatever the issue is? Those are all important considerations prior to undertaking litigation. So let's talk about assessments. Assessments is the funding mechanism for associations. Now, of course, there is borrowing, there's donations, but primarily what you're going to see for funding the association is assessments or dues. And these can be broken down into four general categories. You have annual assessments, which are the base assessments, periodic assessments, however they're titled. They are the regular, ongoing, whether it's monthly, quarterly, or annually, monies that are paid by HOA members to the association. Sometimes the amount is set out in the covenants. Sometimes it's simply based on a budget, but those are the regular dues. Then we have special assessments. Now, almost always when we have special assessments mentioned in our covenants or our bylaws, they're dealing with non-periodic, meaning they don't happen as a regular course. Oftentimes they must be voted on by the HOA members, or sometimes the board can adopt them unilaterally, but often they go for unforeseen budget shortfalls, capital improvements, unexpected capital improvements or expenses of the association. That's hence the special moniker for them. I do have some associations that have language in their covenants or bylaws that use the term special assessment, and it really is an individual or specific assessment. The next general category when we think of assessment types is the type that is individualized. It goes just for one specific lot or individual. And this is usually under the umbrella of monetary penalties or fines, something that the association charges or recovers because of someone's failure to meet the covenants. For example, if there's language about individual maintaining a roof, and if they fail to do so, the association give them notice, then come in, re-roof it, and then turn around and assess the cost to the individual. that would be typically called, or what we would understand to be, a specific or an individual assessment. Then there are reserve assessments. Now, a reserve might not be familiar to you because we have absolutely no law in Oklahoma dealing with reserves, even for condos, which puts us very behind the times. But a reserve is a savings account, not just a slush fund. It's not, okay, we have some pennies left over at the end of the year, we're just going to throw them in this account. It is a specific savings plan to fund what we know is going to wear out, and that's capital improvements. Typically, our reserve plan is based on some third party professional, sometimes a commercial inspector, appraiser, sometimes a civil engineer. But whoever it is, it's based on, all right, in so many years, we know we're going to have to resurface the pool, or we're going to have to resurface the private roads, or we are possibly going to have an insurance deductible in the future. And so, for example, there are many condo associations with 50, 75, $100,000 deductibles on their insurance policies. Well, if you don't have that saved up, we're going to have to figure out how to raise that money to access the insurance if there is a claim. And so having that in reserve or in savings is a great idea. There's a question about, is there a distinction between capital improvements and maintenance expenses? That's a great question. I can tell you, again, sorry to sound like a lawyer, but it really depends. And this is something that we have to pay really close attention to when dealing with special assessment clauses. So special assessments, oftentimes, they have limiting language, and I was thinking I had a slide, but perhaps I don't on this. Um, with special assessment clauses, sometimes they are limited to capital improvements only. And sometimes they define what a capital improvement is. Sometimes they're limited and in scope of, you can only do this for 1 year, meaning you can't spread the pain over 3 years. If you've got, $1,000 per unit or lot special assessment that you need, you can't do 333 this year, 333 next year, and then so on. You would have to vote and collect that, or you would have to re-vote. So to answer your question, you really have to look at the language of the special assessment clause to determine whether it does parse out between capital improvements and maintenance expenses, or is the language broad enough that, okay, so I would put budget shortfalls. You just spend all of your money and you don't have enough to meet the expenses of the association in December. I would put that under maintenance expenses. And if your special assessment clause isn't really limited in its language, then you could adopt one and use it. But if the special assessment clause says for capital improvements only, well, the OG&E bill or paying the landscaper, those aren't capital improvements. So, some of these points to think about: if your association is still using paper ledgers, there are much better ways to keep the association's accounting, at least an Excel spreadsheet, if not accounting programs like QuickBooks or some of the others. This allows better tracking, better invoicing, and response to title companies, and also allows you to put those documents very easily online and provide the HOA members with books and records without having to actually make copies or scan and all of that. We talked a little bit about collections. I'll say more about that in a second. But one of the main questions that clients always ask us when it comes to collections is, will we collect? And there are various factors that we can evaluate that will help predict whether you're going to collect. But there is, again, no lawyer that can tell you, yes, you're going to collect this money and you're going to get all of your money back and all that. There's just too many factors to be able to make that kind of prediction. But what we can get right are the things that are incumbent or at least in our control, and that's making sure that the account shows the correct amount and interest. So, for example, if the declaration provides for penalty or delinquent interest at 12%, and there's an unfiled set of bylaws that provide for 18%, we have to go with the 12%. Or we have to amend the covenants to match the bylaws. And from that point on, we can continue using the 18%. We come across this $25 late fee routinely. And if the covenants don't provide for $25 late fee, or if the the covenants don't provide for some kind of mechanism like board resolution or policy adopting a late fee, you can't simply just tack that on. Certainly can't tack that on when the covenants are clear about what the association can recover in terms of penalty interest. All right. And then establishing policies, procedures, title company contact. And most of the time, if the association has hired a management company, they will take care of all of this. But the board can't simply rely on what a manager tells them. You can't rely on a manager to give you legal advice on whether you should enter a foreclosure. Certainly shouldn't take that legal advice if they tell you, oh, no one ever collects anything in foreclosure, so just throw that in the trash or ignore it. You also can't take their legal advice that we're going to tack on $25 and really um, you know, boost the collections and make people appreciate paying their assessments on time. You would want to either read the covenants and form your own opinion, or actually talk to a lawyer who can give you proper advice on collections as opposed to relying on a non-lawyer. Now, regarding lien practice, we see this with managers as well. A manager has absolutely no authority to sign and file a lien, just like your attorney doesn't have the authority to sign and file a deed on your behalf unless you execute a power of attorney to that individual, whether it's a manager or an attorney, and that power of attorney is recorded every time with those documents that are being filed. So again, kind of like with late fees, interpretation of covenants, a manager does not have the authority to sign and file a lien absent a power of attorney. So it's important that whether it's your manager, attorney, third-party collector, that they understand what statute of limitations means, how the lien laws work, FDCPA, which stands for Fair Debt Collection Practices Act, and the Bankruptcy Code. There's a question. Does Oklahoma law stipulate the language definition of what constitutes a special assessment, or can the HOA define it as it sees fit? Oklahoma law says nothing about special assessments either. There's general language in the Unit Ownership Estate Act that whatever is in the declaration or the bylaws goes. There is section 852, which talks about periodic charges for an association, provided there's language in the covenants that give them that authority, and that it can be the subject of a lien, and that lien can be foreclosed in like manner as a mortgage. That's about the extent of it. There's nothing fleshing out in the law this concept or definition of special assessment. So the second part of your question, or can the HOA define it as it sees fit? The definition can be set out in the covenants, the mechanism for adopting it, but the association board doesn't just have the authority to adopt it absent clear language in the covenants. So The answer to your question is a partial yes. We can have variations on how special assessments are adopted, what they can be adopted for, payment mechanisms, those kinds of things, but it all has to be spelled out clearly in the covenants. All right, let's talk a little bit more about liens. Sometimes there is just this idea that, well, we have a mandatory association, people pay their dues, therefore the association has the authority to file liens. And that's not necessarily true. The, we have to have, and this goes for so many things across the board, if the law doesn't supply us with a definition, or if the law doesn't supply the association or lot owner with a certain right or responsibility, then it comes down to what the covenants say. And so if the covenants, I've never seen this, but if for some reason a developer or a group of lot owners decided, you know what, we want to have a mandatory association, but we want to absolutely prohibit lien filing, you could have a set of covenants that prohibited lien filing, but still required mandatory payment of assessments. So, like I said, I've never seen that. That would be odd, but ostensibly you could do that. Something I hear occasionally, this second bullet about MMLs, mechanics, materialmen, and laborers liens, uh, commonly abbreviated to MMLs. That is a different kind of lien. That is, if you hire a roofer, you don't pay them, they're able, under certain procedures, a completely different set of statutes from condos and HOAs, to file a lien. And those liens, those MMLs, must be foreclosed within 1 year. That is not the same with condo and association liens. Condo and association liens are treated like mortgages, where the mortgage must be foreclosed, um, but not with respect to a time period. The time period for liens is the same time period that the underlying debt uh, uh, has attached to. So, for example, if you have a set of covenants, it's in the nature of a written contract, and that's a 5-year statute of limitations in Oklahoma. The fact that you refile a lien every year doesn't extend that 5-year statute of limitations. In order to stop or beat, so to speak, the statute of limitations, you would have to file a lawsuit for collections. The lien, filing it or otherwise, is simply evidence of a debt. It is not the debt, and which is why the statute of limitations, whether it's a 3-year, 5-year, applies to when the debt was owed, and not when the lien was filed. All right. One of the things that associations want to make sure is that they have the ability to be contacted by title companies. That is probably the surest and easiest way, right behind people just paying the dues because they received an invoice from the association. So if there is a property closing, title company will reach out. They will search out someone who can give them a closing letter. And our office gets emails, gets calls from title companies trying to track down someone from an association. Well, have a social media account, have a Nextdoor account, have a website with a public facing ability, set up a Google business address, whatever that looks like for your association, something so that it makes it easy for the title company to find you and have a current contact for purposes of, does the association claim any kind of money owed on this particular property? We already talked about who signs. I said the manager can't sign, so begs the question, who does sign it? Well, it's a director or officer, unless the covenants themselves specify, which there's no really good reason to have this kind of specificity in your covenants, but some covenants will require the lien to be signed by a president and possibly attested to by a secretary. Again, there's nothing in the law that requires president, secretary to sign, just a duly authorized agent, officer, director, or someone with a power of attorney. But again, if you have specific covenant language, you got to follow it. So double check the covenants in that regard. We talked a bit about small claims. This is a little more information on the small claims collections process. It's always a bit of a challenge, I guess I should say, or a bit of an analysis to determine, okay, do we file in small claims court? Do you file in district court? Do you file a lien and foreclose on the lien and also go for a money judgment? This is all part of um, the collections analysis, looking at the debtor themselves, looking at the property and its equity, and then also whether to file in small claims or district court. So and there's benefits and detriments on both sides. Small claims, generally, you don't have to have a lawyer in Oklahoma to go to small claims court. So you could avoid that expense if you wanted to. There's no discovery really in small claims court. There's no motions practice really. And I say that because there are some discovery tools, there are some motions, but not like in district court. You're usually going to have a trial very quickly, which may be the biggest benefit to pursuing collections in small claims as opposed to district court, because district court can and often takes a very long time. Um, Most of the time, I should say, if not almost all the time, there's no appeal in small claims. It's not that you can't appeal, it's just most people do not appeal adverse judgments in small claims. And this, I think, is more tied to economics than anything else. Because the jurisdictional limit is 10,000, it's going to cost you, if you do hire an attorney, several thousands of dollars to do an appeal, and it's very difficult to do a pro se appeal, or at least statistically it is, from what you see in returns on not hiring an attorney in an appeal. So there are some positives to doing small claims collections versus going to district court. Ultimately, though, whether it's small claims or district court, you have to collect your judgment. Court can give you a piece of paper that says you're owed money, but if a person doesn't simply pay the judgment, you have to go collect it. And there are statutory remedies, procedures for collecting that. One of the comments on liens, did you say an association manager cannot sign the liens? I absolutely said that. Yes. An association manager has no authority under the law, their management agreement, to sign and file a lien, except if the board has executed a power of attorney, a durable power of attorney, and that power of attorney gives the association manager the authority to sign and file the lien, and that power of attorney is filed along with every single lien. All right. There is no general authority for managers just to sign and file liens. It's very convenient, but so is beating someone over the head with a bat to take their money. But just because something's convenient and easy doesn't make it legal. This question, what about when the board is the one breaking the CCR? For example, condo sales collapse due to improper assurance. I'm not going to be able to answer that. you reference a CCR. So you would have to look at the facts. You would have to look at what the covenants themselves actually say. Your question about, is this a small claims court item? If it deals with money and it's under $10,000, then it could be a small claims item. If what you really want is the judge or, well, the judge to make the board do something, well, then no, you can't do that in small claims court. That would be an injunction. Um, I don't know based on this. It may be that your association can't get insurance because the product's not available. There is a clause in the covenants that requires insurance that doesn't exist anymore. It may be that it is cost prohibitive, but there's always the ability, like we talked in part one, if a person is aggrieved by what the board is doing, then the best position is to be in the driver's seat and to get on the board and make that decision, whatever it is, whether it's placing this insurance or doing this or that. So in terms of condo foreclosure, number one thing that we look at is, do we have a manager signing and filing liens without the authority? Because if they do, it's not a valid lien. And we have to go through and do the lien process again. I already mentioned you don't have to file liens every year. All you need to do is file one good lien, and it continues to evidence the debt until it is removed or it is foreclosed. The manager that you're using, the attorney that you're using, whoever, must be in a position to check bankruptcies, because that is going to not only keep the association in compliance with the bankruptcy code, but it's also going to give you really good information on the collectability of the debt. And so if you're not familiar with HOA condo foreclosures, it happens in two instances. One, the association gets served with a petition and summons from a lender. Typically, it's a national lender, could be a local lender. But the mortgage company who issued a mortgage in order for the individual to buy the condo unit or the lot, the home, they're not being paid what they're owed, and so they file a foreclosure. Now, they're not asking the association to pay anything. The fact that the association is named in the foreclosure, it's a title clearing procedure. So anyone who has any kind of claim in the property is going to get named in the foreclosure. The debtor, the defendant, the lot owner, um, the um, the county if they are owed taxes, and oftentimes the association um, will be named. Sometimes whether or not they have a lien, and if there is a lien, they almost most certainly will be named in the lawsuit. Now, whether the association wants to enter an appearance in that suit, that's part of the analysis of, can we come up with a reasonable determination of collectability? And that is a very case by case basis. There is no general yes, you are, or no, you're not. The other instance where the association would be involved in a foreclosure is if the association files the lawsuit and files for foreclosure. Usually, more often, we see those in condo cases, sometimes with homeowners associations, but just again, because of the economics of it, the dollar amounts for collections are typically higher with condos because those are a little bit different kind of animal than HOA debt. All right, so a couple of questions. Is there a time limit, statute of limitations between when you file the lien and when the lien can be foreclosed? Um, no, there's not. However, once again, what you're collecting is the debt. So for example, if if in year one the debt becomes due, and then in year five you file a lien to give evidence of that debt, in year six that debt is gone unless you have sued on it, because the debt is on a written contract is a 5-year statute of limitations. So filing the lien doesn't do anything regarding statute of limitations. All it does is give evidence of the debt. Now, when it comes time to foreclose, you foreclose the lien, but the lien has to be valid. And if the debt is invalid, the lien would be invalid and you wouldn't be able to foreclose it. So I hope that clarifies things a little bit. But we really need to divorce our thinking that the lien does anything in terms of collecting the debt, apart from we can foreclose on the lien, but it doesn't extend the debt. It doesn't better the debt. All it does is evidence it. The question about should you process a new lien if the debt owed increases each year? No. What you need to do is simply file one good lien one time, and that good lien has a couple of functions or facets, I should say. One, it's signed by the right person. Two, it has the amount of the then owed debt, and then also a statement that the lien secures presently owed debt plus all future accruing principal, interest, cost, attorney's fees, all of that. So you do that continuing lien language and you don't have to file over and over. We see sometimes associations doing that, management companies doing that. You don't have to file a lien every year. Just file one good one and you're good to go. Some of the things to be aware of with bankruptcy. It's very common that an individual will file bankruptcy, but they want to keep their house, and so they will reaffirm that debt. That would require them to continue paying HOA dues to stay in the property. One of the reasons why on a prior slide I mentioned your manager who is sending demand letters, certainly any manager who's filing liens has to be able to check bankruptcy, because the automatic stay goes into place. That prevents any further collections, which would include managers filing liens rightly or wrongly. And so that's something that you would need to be aware of. So that's a very, very quick, short primer on bankruptcy. If there's more questions on collections, I'm happy to cover them. Just put them in the chat. But we are going to move on to amendments now. So I want you to take a moment, read this language. If you can decipher what this restriction is talking about, put it in the chat. Usually we're in a room together and I can have a show of hands, but if you have an idea of what this is talking about, put it in the chat. So it says no shooting from boats except for cripples, and in no event shall a motor be running in so doing, open parentheses, the boat shall not be in forward motion, period, no close parentheses. And I have reproduced this verbatim from the language that's recorded in the county clerk's office. That language is dealing with a sportswoman's ethic, where it's considered bad ethics, bad behavior to shoot birds while they're sitting on the water, unless they're wounded, which is called a cripple, and then you can put them out of their misery. So it's an attempt to put into words this sports person's ethic. Just gets it really wrong. So whether the language is bad like that, whether the language is obsolete. So for example, there are many covenants that deal with satellite dishes. Well, in 1996, Congress adopted the Telecommunications Act of 1996, provides the language that if you have an over-the-air reception device, commonly known as OTARD, if you have one of those and it is 1 meter or less in diameter, you can put it wherever you need to get a great signal. And so if there's a covenant that's been on file since the 70s or 80s that says no satellite dishes may be visible from the street or adjoining property, well, that covenant must give way to the federal act. Just like if there is a state statute that preempts covenant language. You know, we mentioned something about a pending bill uh, outlawing the ability for associations or covenants to dictate the terms on solar panels. That is not law, but if it had been adopted, that bill would preempt whatever covenants say about solar panels. So if we have a situation where we have old language, we have dysfunctional language, or we have language that just it leaves your head spinning or scratching trying to figure out what it means, well, then maybe we need to amend. So the two things to think about when it comes to covenant amendments, and that's number one, we're going to look at the language of the covenant itself. That's bullet two, follow the amendment provision within the document. So it's very common for covenants to have its own amendment clause, and whatever those provisions are, then you could follow that. Or you can use a state statute, which was adopted many, many years ago, for the specific purpose of giving property owners a pathway to amend their covenants. And that is this 11 OS 42-106.1. And the statute works in conjunction with the declaration or covenants that you're working with. So, for example, if the covenants require 90%, which is an exceptionally high percentage, and the covenants have been on file for, say, at least 15 years, well, then 106.1 will allow you to use either the 90%, or you can follow the state statute and use a 60% because the covenants have been on file for 15 years. If covenants under 106.1, if covenants have been on file for only 10 years, then the percentage is 70%, 70%. So some of the common questions with amendments is, well, what kind of vote is this? Can we just raise our hands? Can we adopt it with a simple majority if we have a quorum? The answer to all of those are no, unless the covenants make it abundantly clear you're going to vote like corporate members and it's not a real estate vote. If there's any indication that there must be an acknowledgement, some kind of written consent by property owners, then they have to be acknowledged ballots executed by each lot owner to a lot in order to count that ballot. So what that means is if husband and wife own a lot, they both must execute a ballot, not necessarily the same ballot, but it must be notarized and filed with the amendment. Two spouses, two brothers, two sisters, mom and dad and kids, two unrelated people, but they own the property together. They have to sign a ballot in order to count that ballot towards your percentage, right? It's important to also pay attention. What percentage is the percentage to be applied against? So the language 60% of the lot owners is very different than the lot owners of 60% of the lots, because one percentage is applied against lot owners, the other percentage is against lots. So we have to be really careful, pay close attention to not only the percentage, but also what is that percentage applied against, right? Now at the bottom here, this is why when we start talking about amendments, it's very important to have in our minds clarity between covenants and bylaws. And this is also a dividing line between condominium associations and non-condo associations. 106.1 is for non-condo associations. The Unit Ownership Estate Act has very specific requirements in terms of percentages for for condo associations. So we have to pay attention to that. We also have to pay attention when it comes to bylaw amendments. If we're dealing with condo associations, this 180S 1013, in my opinion, doesn't apply. Could be definitely wrong. I'm waiting for a court case on this for some kind of clarity. But the thing here is 18 OS 1013 speaks to the corporation code procedures for amending corporate bylaws. There is a specific statute in the Unit Ownership Estate Act that deals with condo bylaws. So generally speaking, when you have a specific statute that applies to specific circumstances, you go with that as opposed to the general. That's why I think if we're talking about condos, we can't use 106.1 and we can't use 18 OS 1013, but otherwise we can. And for non-condo corporate bylaws, 1013 makes it very, very easy to amend because the board itself can amend the bylaws, meaning you don't have to get the general membership's approval. The board can amend the bylaws themselves. This is why I think you see some associations and even some lawyers I've seen do this. They will have the board amend bylaws to put what they want because it's hard to amend the covenants. So, for example, there was a lawyer that assisted an association to put a leasing restriction in their bylaws as opposed to the covenants. Well, that's not enforceable. You can't do that. So it is very easy to amend bylaws because the board could do it themselves, but you can't put in the bylaws what are properly adopted or required to be put in the covenants, like leasing restrictions or how many dogs and cats I can have. That's in a non-condo situation again. So the chat here comments, what if the bylaw states 75% of the owners required to amend bylaws, would 18 OS 1013 still apply? Well, first thing, we would need to determine, are we talking about a condo set of bylaws or not? Because that 75% is the number that's required for condo bylaws. So if we're talking about condo bylaws, 18 OS 1013 would not apply at all. But if the bylaws are non-condo bylaws and they say these bylaws may be amended by 75% of the owners, 1013 would still apply. In fact, the statute was amended a few years ago to make it abundantly clear that irrespective of what the bylaws say, how they're amended, and even if they say only amended by the members, the board can still do it. And so 1013 is really functional. Now, what happens is if a board gets out over their skis and um, uh, makes an amendment, say for example, there's a comprehensive, well drafted, well liked and used due process clause in the bylaws, and the board says, you know what, we've had enough of this, we're getting rid of due process, and the board amends it out. Well, they would have the authority to do that, but there's that would be a unique situation, I guess I will call it. And the members may want to either um, suggest that the board put it back, convince them to put it back. The members adopt a due process clause over the board's objection. And then if the board tries to remove it, you're probably looking at removing that board or having a court determine that the member adopted bylaw can't be removed by the board, something along those lines. Um, so let's talk about a little bit of the mechanics on amendments. So if you're going to spend all of the time, all of the energy going through and trying to get these notarized ballots, you want to have a good sense that the efforts are going to be productive or fruitful, or as best you can determine, are we going to get our vote? Now, kind of like with collections, you don't know ahead of time. Just like in any voting process or any elections, you might have some good indications, but you don't know for certain until you go through it. One of the, one of the things that you can do is have a drafting committee, particularly in neighborhoods with a number of plats or phases. So if you have 500 units over several plats, you may want to get a drafting committee, maybe get your block captains if you have that kind of infrastructure, or make a call for a committee made up of various HOA members from around the neighborhood. And that does a couple of things. One, it helps preserve the board's batteries because I think it's very well known. I'm not speaking out of school that board members tend to do all of the work in the homeowners association, and having committees are a good way to preserve some of the board members' batteries, for one. But for two, it also helps individuals in the neighborhood learn about the covenants, and it puts a different face on it. So sometimes in a neighborhood, it's the board does all of this stuff, and it's just these two opposing sides or appearing to oppose board and everyone else. Well, using committees made up of a few people of the everyone else helps blur that sometimes um, perceived distinction that the board is aloof, they're just making decisions, and if that is a prevailing perception, it's really hard to get people to vote and attend meetings and ultimately pass a covenant amendment. Testing the waters, whether it's testing the waters with a drafting committee and talking, over the fence, or doing formal surveys, whether it's in the mail, whether it's using companies like SurveyMonkey, or I think some of the social media platforms you can do surveys. I know with Zoom and some of the other conferencing applications, you can also do surveys. And so, however you get that information, asking questions, do you have a copy of the covenants? Have you reviewed the covenants? When was the last time you reviewed? Getting information about um, maybe other things other than, hey, we want to amend the covenants, are you in favor? You want to get some more information, not just about covenant amendments, but also while you're at it, maybe we need to identify how to get better information about the covenants out there. If the association doesn't have a website, if there's not an owner portal, if there's not a means to email directly, I mean, push the information as opposed to just having all of this pull information, pushing the covenants into people's inboxes or awareness, well, then testing the waters can include getting survey information on that. It's very common that in the voting process, we will schedule information meetings. And that's exactly what it is. At an information meeting, whether it's about a covenant amendment or something else, um, there's no vote taken, there's no sign in, there's no quorum. It is simply to pass information. Now, oftentimes at these covenant amendment information meetings, we will collect ballots because we have most of the time already started the voting process, meaning we've sent out the notice that the project is starting. Here is the drop dead voting date, voting meeting date. We are going to be going door to door collecting ballots. We're going to have one or more information meetings. The lawyer's going to be there to answer questions, whatever. And so at these information meetings, typically I'll appear, I'll answer procedural questions, I'll answer substantive questions, I can answer all of the questions about, well, leasing restrictions are illegal, they're taking away property rights, all of those arguments. We can have a good faith civil discussion on all of that. And then based on that discussion and people's inclinations and opinions, they can decide for themselves and either vote or not. Um, Comment. So an information meeting is kind of like an unofficial meeting where you can just kick people out. um, I don't know why you would just kick people out of a regular meeting or information meeting. I'm not sure I know how to answer that. Um, the only time a person needs to be kicked out of a meeting, official or unofficial, is when they're not behaving themselves and they're becoming an impediment to having the meeting. That's when people should be kicked out of a meeting. Otherwise, the whole purpose of this is for communication, or if, like I said, part one, if it's a board meeting, if an individual who's not on the board can't behave themselves and they're interrupting, well, then of course they need to be asked to observe civility, public discourse, meeting rules if there are any. They certainly need to be invited to behave themselves, and then if they can't, then invited to leave. And if they don't accept that invitation, then maybe at that point they get kicked out. Um, this the comment about, I guess I could go to small claims court. I don't see a connection between having an unofficial meeting, someone getting kicked out, and going to small claims court. But maybe you can elaborate in the comments on that. Again, a person goes to small claims court to collect money or collect property. A person couldn't go to small claims court and get relief, at least none that I can think of right now, in any way relative to getting kicked out of a meeting, official, unofficial, voting, non-voting. Small claims wouldn't be able to remedy that. Back to amendments, something about voting ballots and all in or line item. Well, what I'm talking about here is there are some covenant amendments that are so complicated. So, for example, our hypothetical of you've got 500 units or 500 lots, houses, whatever you want to call them, over multiple plats, and you are consolidating all the different covenants for them. You're adding a definition section, you're modifying all of this stuff. Well, at some point, your voting ballot, if you do a line item for each of those changes, it's so complex and so confusing, it's not worth doing. And so at that point, you may just have just a voting ballot and it's not a line item, meaning you approve it or you don't approve it. If you have, say, a handful of amendments, so it's real common to do leasing restriction, um, combined with specific assessments, adding in due process, and then maybe there's a special issue like basketball goals. Do we want them? Do we not? Well, those are not necessarily interrelated, so you might be able to do a line item ballot. So it is possible to say, you know what, I want to lease my property, and so I want to vote against that. But the basketball playing is driving me crazy. I don't want that. I'm all for due process, and I'm on the fence about. So it lets people pick and choose, but not one of those has to pass and along with another one. One could pass, all of them could pass and interrelated. So that's what that's saying. Ultimately, um, if there is a valid percentage hit and you have the ballots requisite to that percentage, then ultimately the covenant amendment could be recorded. and that amendment from that point on would be effective. Now, you wouldn't be able to file something and apply it retroactively, meaning, and this would never happen, so it's a silly hypothetical, but it illustrates it. So if you have a covenant that said 2,000 square foot houses only, everybody builds 2,000 square foot houses, or 2,500, you wouldn't be able to come in and adopt a covenant that required 2,500 square foot houses, and now everybody has to go add 500 who doesn't already meet that. You wouldn't be able to actively that. There's a comment, what if amendments were passed but ballots were not notarized? Are the amendments invalid? It entirely depends on what the covenants say, what the bylaws say, what the amendment is. It's entirely fact-based and also based on the covenants in order to determine if it's valid. One of the things that we do when we take an amendment project, the very first thing that we do is we prepare a governing document index and file. You don't know what you're amending. You don't know whether you need to amend it until you know where you're starting from. And it doesn't happen all that often, but sometimes it happens where someone comes to us and says, hey, we want to amend our covenants to say X. And lo and behold, I do some research and I find all of their covenants, I organize them, and then I look through them and they have that language already. Well, you don't need to spend all the time and money amending the covenants for something that's already there. And so that's the very first step. And then the next step that we do is we prepare an amendment memo, which is a legal opinion on what does it take to validly amend the covenants or the bylaws. And that helps avoid the question that owner has. What if amendments were passed, but ballots were not notarized? Is the amendment invalid? Well, we don't know on the back end. We don't want to have just guesswork. We want to know what our target is, so that's what we can aim and shoot at. And so going into the project, before we ever draft the ballot, before we ever draft the proposed amendment, uh, we do a legal opinion that answers, okay, this is exactly what it looks like. Because there's no sense in spending thousands of dollars and spending time with a lawyer drafting all of this stuff and coming up with this really good amendment language and then find out, oh my, it's going to take 100% approval in order to adopt this, which is possible. I mean, wouldn't we want to know that ahead of time? So it for us, at least when we do these projects, we want to know what the map looks like, and that's the very first step that we do, so that we don't ever get to the end and wonder, do we have to have notarized ballots or not? We know that before we draft the ballot. Great question, though. All right, let's talk about insurance. There was a comment about insurance. There are some generalities that we can speak to about insurance, but ultimately, I'll tell you, if the insurance clause in your covenants don't meet either what's available on the market, what's available for the association's budget, or is just dysfunctional, well, then you might be looking at an amendment to fix that. So for example, if you have a condo association and there's not a requirement that an individual unit owner place an HO6 policy and have loss assessment, you might consider putting that in your covenants or your bylaws, your condo covenants or bylaws, because there's very good condo unit insurance that's cost effective out there that will help pay for special assessments, and can help condos mitigate some of those really large deductibles that condo associations are facing. So again, if you don't have the language, you might be looking at an amendment clause um, as opposed to trying to shoehorn into whatever that is. So Insurance, as we all know, it protects against casualty, property damage, and liabilities, slip and falls, breach of fiduciary duty, all of that kind of stuff. There are specialized insurance packages for community associations. There are also very well known, very established out of state insurers that can place policies in Oklahoma for your association. So you don't have to simply rely on the standard names. There are others out there. There's something called director and officers insurance. That's often a rider, although you can get a standalone policy for that. And again, like I mentioned, we want to make sure that the insurance fits the governing documents. In other words, again, in a condo, I keep using condos because when it comes to insurance, um, and condos, insurance is very important, and this is where we can have this gap, this mismatch of what the governing documents require and then what insurance is placed. Um, so there are policies called blanket policies. There are also bare bones policies for condos. And if the governing documents require one and you place the other, then we may have this gap in what the covenants require and what was actually placed. Um, so one of the main reasons why you have insurance, apart from covering these casualties and the possibility that there's a liability, is what's called the duty to defend clause. And oftentimes that duty to defend clause is broader than the actual coverage. And what that duty to defend does is, if it applies, then the insurance company will hire a lawyer to defend the association. Now, they're not going to hire a lawyer for the association to bring a claim against an individual. They haven't paid their dues. Your insurance company is not going to hire a lawyer to go collect it. Only if there is a claim made against the association or the directors and officers if you have D&O coverage. So if there's more questions on insurance, I'll certainly try to answer them. One, do HOA board members have any personal liability for HOA debts or lawsuits necessitating a D&O or other policy? I can't answer it if they have personal liability. I'll say a couple of things. So um, there is something called piercing the corporate veil. If a corporation is being used as what's called a thinly capitalized corporation, I've never seen that successfully argued for a homeowners association, but it's out there. If board members co-sign on loans, then they could have personal liability for an HOA debt. Now, one of the things to consider is the way our court system works is the door is like this, meaning it's wide open. So anyone can sue anyone for anything. You will get in the court door, and then it's up to the court system, whether it's a motion to dismiss or the threat of sanctions or whatever the mechanism is to resolve that. Uh, Legitimate case going to a bench trial or a jury trial, or a frivolous case getting thrown out by the court on its own. So this is where the duty to defend is important for community associations and its boards is, someone who has a computer or a pen could file a lawsuit against you, can say basically whatever they want, and you'll still have to spend the time resolving that. So the answer is yes, but hopefully there is insurance in place that will provide a defense, and hopefully there are judges who will review a motion to dismiss and a motion for sanctions and take appropriate action. There's a question above that. What about termination of HOA with 90%? How do you verify a person authorized to sign a written instrument if the owner is an LLC? I don't know what the question is about terminating an HOA with 90%. It is possible to terminate an HOA, probably not probable, particularly if there is a plat with common area and it requires a property owners association, like I talked about in part one. If you're in Oklahoma City, if you're in Norman, Tulsa, Broken Arrow, any municipality, you probably have an ordinance that requires the association. So you wouldn't be able to get rid of the association. In terms of how do you verify a person uh, being authorized to sign a written instrument if the owner is an LLC, articles of organization or an operating agreement would be the document that you would look at to determine um, for for establishing who can sign the LLC. Then you ask, so then why did the CCR say that? I don't know. I would have to look at CCRs. There are all kinds of things that CCRs say that don't match the law. For example, satellite dishes and the Telecommunications Act of 1996. So moving on, records. This is a real common thing for boards to struggle with, for HOA members to struggle with. There is a state statute that is often misquoted, often misused in terms of the the way it works is not understood properly. So I want to reiterate from part one, there's nothing that says the board has to respond to an email that is sent by an HOA member. Now, maybe for purposes of customer service, for purposes of answering easy questions, because it's an innocuous enough request that the board should just respond. Maybe ought to, those are all possibilities, but there's nothing that says the board shall answer every email, every demand for answers to questions. There are typically provisions in the governing documents that talk about records inspection. We do have a state statute that talks about records inspection and copying and giving a cause of action in district court if a corporation doesn't provide an opportunity for inspection and copying. That's different than sending an email saying, give me all of the books and records of the association. There is no right, and typically no right in statute, and typically not the right in governing documents for a give me all the books and records demand. This idea that you can just fire all this stuff and snap your fingers, and now this voluntary non-compensated board now has to jump at your every thought, your demand, every question. That's just not a real thing. What is a real thing is putting books and records on a owner portal so that people don't have to chase boards down and make inspection and copying requests. It saves everybody a lot of time. Um, Also, having a system where we don't have to parse out is this tenant duly authorized by their landlord to obtain books and records. Um, just put them in the owner's portal, and if the owner wants to provide their tenant occupant access, then that's on them, not the association. So, who is entitled to inspect and copy an HOA member? They are the shareholder. And when may they demand them? They may demand them to have an inspection and potentially copy them during normal business hours and within a reasonable time. Now, if you look at Title 18, Section 1065, that is the corporate inspection and copying statute. And you can read it. There are very specific requirements for how to make an inspection and copying request. and it is not an email. The 1065 request has to have specific language, identifying information, specifics of request. There is what's called a proper purpose requirement, but that's a pretty loose standard, at least currently in Oklahoma, the way the courts have interpreted that. But there are limits to it. We have a little bit of case law on that. But the statute doesn't require a allowing an individual making a 1065 request to inspect and copy within 5 days of the request. The statute requires the corporation to respond within 5 days. And that response can be, we got your request. We will make the books and records available for your inspection and copying on such date, provided that's a reasonable period of time. So that's how 1065 works. It typically works very smoothly, and oftentimes we don't even need a 1065 request because it is often that an individual has a question that can be satisfied by a record. They know exactly what record they want, and they can ask for it. And they can show up, inspect, and make a copy, and everyone goes about their business. The problem that we see with records requests is when people use it as a club and say, give me all of the books and records of the association. Well, you're not entitled to that. There has to be some kind of um, reasonable mechanism um, uh, for navigating inspection and copying. Uh, One of the comments is, what if the governing documents say the request must be sent to an address that isn't for the association? Then I wouldn't send the request to that address. I would send the request pursuant to 1065 to the registered agent of the corporation. So I think there was one above that. What is the difference in director versus officer? One says they use both terms to removing a board member. One says the HOA needs a majority vote. The other term states we need a two-third vote of the membership. So would a treasurer be a director or officer of the board? I'd have to read the exact language. It's possible that you've got just some garbage provisions, but in terms of the difference between a director and an officer, and I do read bylaws that have these two concepts uh, horribly mixed up, and it is garbage language that needs to be cleaned up in the bylaws. But generally speaking, a director is one of the members of the board of directors that gets elected by the membership. So board members are elected, and then officers have a specific office: president, vice president, treasurer, secretary. And officers under corporate governance are appointed by the directors. Now, oftentimes, say we had a 5-person board. The members elect the 5-person board, and then at the very next board meeting, those board members appoint among themselves the officers. So sometimes on a 5-person board, we'll have president, vice president, secretary, treasurer, and then we'll have a board member at large. We'll have a board member who doesn't have an office. They're just board member at large. Now, whether that's exactly how it works under a particular set of bylaws, we would have to read them. And again, maybe they were written incorrectly. Um, Sometimes bylaws will require the president the president, secretary, treasurer to also be board members. What that means is we can have a vice president, we can have assistant officers, and they don't have to be board members. They can be appointed outside of the board. That's entirely possible, permissible. And in fact, Matt and I used that kind of provision for an association meeting recently where, because of the circumstances, it was more convenient for me and Matt to to appear and to facilitate the meeting. And the bylaws, they required special meetings to be facilitated or called by by the by an officer, and the bylaws also allowed that assistant officers uh, could be appointed by the board and don't have to be even members of the association. So it allowed me, the association's attorney, to facilitate the meeting, and it worked fantastic. Um, so follow-up question, if that's the case, do those appointed officers get a vote on board issues? Well, only board members get votes. And I'm assuming that's how the bylaws are written, that if they are a board member, then at the board meeting, they would vote. So, for example, in my hypothetical, the fact that I was appointed an assistant secretary of that for that evening, that doesn't mean now I get to vote because I'm not on the board. I'm just an assistant officer. So, for example, when you say if that is the case, meaning we have a 5-member board and 4 out of the 5 officers are also board members, well then yes, they would all get a vote, not because they're officers, but because they're elected board members. One of the questions that comes up is, okay, we're talking about books and records. Well, what are the books and records of the association, and how long should we keep them? This is not written in the law anywhere. This is my idea, my slide, my conception of how this should work, and I'm sure you could find someone to disagree with it. But this is kind of my operating list of what books and records there are and how long we should keep them. So indefinitely, keep these forever. Have a 3-ring binder. Don't ever throw it away. Scan them, have them freely available online to all of the members. And that's all the meeting minutes, any resolution, governing documents, which remember from part 1 are the plat, if there is one, covenants, bylaws, plats, design review guidelines, any of that stuff. ARC, remember, is short for Architectural Review Committee. If there are Architectural Review Committee forms, if the ARC happens to keep minutes, that's not all that common, but maybe they do. And then keeping enforcement litigation files. Now, on this one, you don't preserve these so that people can paw through them. You certainly don't just willy-nilly release demand letters or who got fines and all of that stuff. But you do want to keep decisions from courts in the corporate record books, because it's important for board members generations along the line to be able to remember or to find out, oh, we've been down this road before. We had, a full litigation on that brick perimeter fence and whether it's owned by the association or whether it's owned by the lot owners, because that's something that people litigate. Well, if you've spent all of the money and gotten a court decision, and it's possible that decision doesn't get recorded in the real property records, well then you would want to know about it. Tax returns, keep them for 7 years. Audits, you more than likely do not have an audit. By the way, if you have governing documents that require an audit, then that would be front and center for amendment. If you have priced what an audit would be, even if you could find assuming you could find someone to give you an audit, they are incredibly expensive, much too expensive for community associations. Possibly if your association is running a multi-million-dollar annual budget, maybe then you would have an audit. But if your association's annual budget is $30,000, you're going to spend almost all of it, uh, certainly more than half of it, having an audit. Never do that. Reconciled bank statements, by the way, reconciled bank statements reviewed by a group of board members on a monthly basis is one of the best ways to prevent fraud and embezzlement. It's very difficult to have a sustained um, fraud or embezzlement, stealing, when you have a group of individuals um, reviewing reconciled bank statements. Now, of course, somebody can, you know, steal money and be out the door, but you're going to determine it eventually within so many days. And so, on top of having monthly review of reconciled bank statements, having one or more people look at the bank accounts on a daily basis. I don't know if y'all are aware of the recent news report dealing with an HOA manager whose accounts were hacked and HOAs losing substantial amounts of money. But that gives rise to not just checking reconciled bank statements, but also precautions of looking at um, your accounts, and then also determining whether your manager has, um, you know, precautions in place, insurance in place to cover hacking instances, whether there are specific instructions for wire transfers, whether the manager has been given the authority to transfer money, all of that stuff. So those are also good fraud or embezzlement or hacking precautions. And I give a couple of other instances on here, or examples of records: budgets, balance sheets, profit and loss statements for 7 years. Other things that are simply discretionary, whether you keep bids and contracts, invoices, emails, text messages, social media, that's really up to the board. What you can't do is decide you're going to trash all of the text messages, emails, and social media when you get a discovery request in litigation. You should think about that ahead of time. Also think about what you're committing to: text, email, social media, and formalize those means of communications. If the board never communicates by GroupMe, well, it's really easy to respond to a demand that you produce all the GroupMe messages. There aren't any. If the board has a policy that emails are cleansed after, so many years or so many months, well, then just follow that policy. This digitize all records. Once again, if this idea of keeping hard files and that's what gets passed on, um, we really need to move to where those are digitized at some point and either warehoused, or not either, but warehoused and also made available to the members under, password protected portals, or however that happens. But digitizing the records makes records requests so much easier, so much less formal. Question: do HOA members have rights to privacy? Specifically, can HOA distribute owners lists with phone numbers, emails, and addresses? That's a great question. I'm going to answer it a couple of ways. One, um, putting delinquent or alleged or purported delinquent owners' names anywhere and exposing them to the ridicule of their neighbors or the public is never, ever okay. It is a horrible idea. When you're my age, I can remember the names or the pictures or the signs by the sign register, or the cash registers at restaurants and various businesses, publicly shaming people. You don't see that anymore, and you don't see them for very good reason. And so associations don't do that. Your question: um, can the association distribute an owner's list with phone numbers and email addresses? Um, Only if there are uh, directory forms or information forms. So, for example, We've talked about closing letters several times, and oftentimes at closing, there'll be a form to fill out and put your name, address, email. How do you want the association to communicate with you? Do you want your information available in the directory? That's the best way to navigate this expectation of privacy that people have regarding their cell phone numbers and email addresses, kids' birthdays, that kind of stuff. So we can cure that with a release form or information form. Otherwise, the association is on solid ground by providing name and address. That's all easily available by public record. Anything beyond that, the association really should get the person's consent. The association also should get email addresses because um, that's the easiest way for people to execute proxies, to get notices, and to vote. Um, Question: does a homeowner need to opt into electronic communication for notices? Um, Once again, there needs to be some mechanism so that there's no gray area. If that involves an online portal or a form where a person opts in and gives the association their email, then that's fantastic. If there's a form that they fill out, that they give email, and they indicate I want to receive meeting notices and other HOA communications, but I don't want this given out. Well, then we're reducing the gray area or getting rid of it altogether. And so I think, however that looks for your association, if you don't have clarity, if you're not in black and white, well, then the association can provide an ownership list and mailing addresses because that's all very easily publicly available. I've talked about 1065 a bit. 1069 somewhat addresses a somewhat helpful form of records. We have section 521 for condo. There is nothing specific for homeowners association. And I've already covered proper purpose. This power of attorney, you can issue a power of attorney under section 1065 to allow an attorney, ostensibly another person, to allow that individual to do the inspection and copying on your behalf. And then once again, the right is an inspection and copy, not demand answers. And also, it's there is no requirement under 1065 to for the association to create records. Just like the comment about GroupMe, if the board doesn't communicate, then they can't produce that. And if an individual says, "Give me a list of all of the individuals who the association has fined in the last year," well, number one, no, we're not going to provide enforcement files, and number two, we don't have a list. You don't have to create a list. Now, you might have a bunch of files, but unless you have that specific record and produce it in the form that it is normally kept. So, if an individual says, provide all of the bank statements, but I want you to put them in a zip file, and the association doesn't keep them in a zip file. Well, number one, you have an inspection and copying right. Two, you don't have a put it in a form that's convenient to me right either. All right. So I've got a handful of slides left. We may hit this right on the dot. Uh, let's talk about taxes just a little bit. Not because I'm giving you tax advice. This is legal advice. If you go to Title 18, it's not legal advice. It's under the the realm of legal issues. Sorry for that misspeaking. If you go to Title 18, Section 865 through 867, you're going to find a series of statutes that are very helpful for liability limitation to our volunteer, non-compensated board members and our nonprofit, non-stock corporations. And in a nutshell, what it says is if your association files this Form 1120H, and 1120H is a federal corporate tax form. It's a single page um, tax return that's filed every year by a residential condo or homeowners association, not commercial associations, but only residential ones. It's a specific exemption that was adopted under the Internal Revenue Code, Section 528, many years ago by Congress. And it's very helpful because what it does, uh, filing this Form 1120H not only is helpful on taxes and dramatically streamlining the tax return process for residential condo and HOAs, but with Oklahoma law, what it does is it gets rid of simple negligence for the board and the association, and it ramps it up to gross negligence. It also gets rid of joint and several liability. So me serving on an HOA board doesn't somehow make me negligent if or liable if another board member is grossly negligent. It just doesn't flow to me. I'm only going to be responsible for my intentional acts and my gross negligence. And it also makes it abundantly clear that there is no breach of fiduciary duty claim, although we hear this all the time, that the board didn't do something I like, so they're breaching their fiduciary duty, or they haven't done this or that under the covenant, so they're breaching their fiduciary duty, completely ignoring everything about business judgment and discretion. But what this statute does is it makes it abundantly clear there is no breach of fiduciary duty claim against board members except for breach of duty of loyalty, lacking good faith or intentional conduct, or gaining an improper personal benefit. This happens to actually be the exact same or substantially similar same standard under Title 18, Section 1027E, which means if you read that statute, it means if you have good faith, if you rely on the books and records of the association, if you hire professionals to give you advice, you know, engineers, attorneys, accountants, well, then you should be able to rely on that advice and you're going to have complete immunity from people claiming you got it wrong and you breached your duty. So, very, very helpful uh, statutes, both 18 OS 865 and 1027E. And I do have a slide coming up on 1027E. There's a question here. How are architectural plan specification plot plans to be submitted to the HOA? Should that method be spelled out in the bylaws? Probably not spelled out in the bylaws. They could be spelled out in the covenants. Um, People could reasonably debate, should that method be spelled out? I think it should, or I think, well, of course, the architectural review committee process has to be spelled out in the covenants. Now, whether the process on how that works is spelled out in the covenants or somewhere else, I'm kind of indifferent as long as it's abundantly clear and it's almost a push information if it's not spelled out in the covenants. Oftentimes you don't have forms like a form to use to make architectural submittals and doesn't have an outline of everything that you need. Um, I attach a form to all of the covenants that I do for developers just because it makes it handy and it's all in one package. So whether it's here, there, or somewhere else, as long as it's clear, as long as anyone who reasonably wanted to discover the form, the procedure, they'd be able to do it. So, for example, if anyone with a computer were to Google Happy Acres Architectural Committee form process, and you're going to be the number one Google hit, I mean, that's reasonable notice in my mind. So the answer to your question is yes. Now, something while I'm talking about it, and I'll talk kind of quickly because we're running out of time. There is some dangerous language in a lot of covenants that says if the architectural committee doesn't receive a properly submitted written application within 30 days, or in the event suit to stop the violation isn't filed before it's completed, then this section doesn't have to be complied with. That's dangerous language because if we're talking about someone who leaves a written application on someone's front door and we don't have clear language in the covenants that says that's impermissible, and then 30 days goes by and now they claim they have approval. Well, now we're off and running in gray land, and a lot of those issues get litigated. So uh, if you're looking to amend your covenants, taking that language out, putting in clear language so that we're not dealing with gray, or at least pointing people to somewhere to find the right procedure, then those are all good practices. Anything that clarifies, that gets us more into the land of reasonableness, that's what we want to do. All right, a couple of bullets in the remaining time. If you're on the board or if you're an individual owner wanting to know what your rights, your responsibilities are, one of the things that you want to do is look for the shalls. You can print off your covenants, your bylaws, and you want to highlight or circle shall. So in contracts and in statutory interpretation, shall is a non-delegable duty. And so if there is a shall, then absent a handful of excuses, legal excuses like impossibility, frustration of opportunity or performance, impossibility, things like that, then we're to interpret shall as you got to do it. Now, if we have the board shall administer the association, um, and then it gives some duties. Well, those are all going to be tempered by the business judgment rule. It's entirely appropriate if we have the board shall language in the covenants or bylaws that says the board shall administer the common areas for the use and enjoyment of the lot owners. They're going to administer the common areas in the business judgment of the association. And the fact that someone thinks the trees that died in the common area behind their property have to be replaced immediately, and they file suit against the board or the association to replace those trees, at least on prior cases, they're going to lose that lawsuit or should lose that lawsuit because courts find that the fact that there were trees in the common area, that they die, and you make a demand on the association to replace them, the board could, in its business judgment, say, we're going to spend the money somewhere else. That case was litigated in small claims court a long, long time ago. The small claims judge took the extraordinary time to do the research and find outside of Oklahoma cases, wrote a fantastic opinion. And I believe that judge is retired now, but gave us a really good, albeit unpublished opinion. And this was in the Coffee Creek edition in Edmond, Oklahoma. Uh, for time purposes, I'm going to not talk about duty of loyalty, duty of self-dealing, but these are the fiduciary duties. Fiduciary duty does not mean boards have to do what people demand on them. Otherwise, they have breached a duty. That's not how that works. Here's the slide on 1027E. This is just a reproduction of the statute. But like I said, it anytime a board or officer relies on the records of the corporation, good faith of the employees or the professionals hired by the association, they have full immunity from liability. So it's a very good protection for the very good people in most cases who serve their neighbors voluntarily and without compensation. So with that, I'm going to wrap it up. Thank you for everyone joining us. Appreciate it. And thank you for the comments. And I will see you the next time that we do one of these series. All right, Catherine?
Thank
Thanks,
you,
Matt.
Matthew. That was great as always. Really appreciate you. And just a reminder that as soon as, feel free to email or call and check or just look yourself, but we will be posting the video on our website and our YouTube channel just as soon as we get them edited and compiled. So thank you, everyone.
Thank you.